Chevron, but I told them that I really agree with, with the decision. And
I think we got that fourth, right?
I think it's fourth. So I don't know if you wanted to hold it. I think we could work on it.
We'll probably do. Committee will come to order without objection. The chair is authorized to declare recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. Now recognize the gentleman from North Carolina, Mr. Knott, to lead us in the Pledge of Allegiance.
To the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank the gentleman from North Carolina. Pursuant to notice, I call up H.R. 1789, the Promptly Ending Political Prosecution and Executive Retaliation Act for purpose of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1789.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from South Carolina, Mr. Fry, the sponsor of the legislation, for an opening statement.
Thank you, Mr. Chairman. H.R. 1789, the Promptly Ending Political Prosecutions and Executive Retaliation Act of 2025, would place a check on radical left-wing prosecutors, or really any prosecutor's ability to bring politically motivated criminal cases before judges and juries that may be biased. The last few years have brought about outrageous and unprecedented moves from rogue prosecutors to target one of our nation's top leaders for their own political gain. For the first time in American history, a former president was indicted and faced with criminal charges. After President Trump announced his 2024 presidential campaign, he was indicted not just once, twice, or three times, but four. And two of these indictments have come from rogue district attorneys looking to build up their profile, as this committee has explored last Congress, and make a name for themselves on the national stage. In April of 2023, Manhattan DA Alvin Bragg sentenced or announced a 34-count felony indictment against President Trump in the New York State Supreme Court. Instead of prosecuting real crime in New York, as we witnessed in this committee, that they continue to face, DA Alvin Bragg made President Trump the focal point of his campaign. And then again in August of 2023, Fulton County DA Fannie Willis brought about a 41-count indictment against 19 defendants, including President Trump, in the Fulton County Superior Court. Willis even told the news outlets, quote, "We've been working for 2.5 years, we're ready to go," end quote. They could have brought charges years earlier, but decided to do it as soon as President Trump announced his re-election campaign. These politically motivated district attorneys did everything they could to keep Donald Trump out of the White House, and well, we all know that it backfired as the American people gave President Trump a resounding mandate to restore our country's greatness. The American people saw the political persecution led by the Biden-Harris Justice Department's two-tier justice system that extended to Democrat, local, and state offices. These were bogus indictments, and our rule of law must be protected. The president is the leader of the free world. The level here is not the same. A small-town prosecutor coming in and attacking our commander-in-chief is laughable. We don't do this in America. We never have. And we can't continue to allow America to turn into a country where candidates running for office are prosecuted out of purely political reasons. These prosecutors have weaponized our justice system against its political opponents, and it is Congress's duty to respond, which is why I have introduced this bill and a similar bill from last Congress, which would give both current and former presidents and vice presidents the ability, not a mandate, but the ability to remove their civil or criminal cases against them from a state court to a federal district court. The new bill also expands the eligibility to remove cases also to current and former U.S. officers who are acting within the scope of their official duties or apparent legal authority related to their office. The bill also codifies the immunity recognized by the U.S. Supreme Court for official acts carried out by federal officials. The federal interests implicated by civil actions or criminal prosecutions brought against current or former presidents and vice presidents are pretty overwhelming. A federal court is the appropriate forum to adjudicate cases with such a strong federal nexus. Federal judges, as an example, enjoy life tenure that is largely free from outside interference in their decisions. By contrast, state court judges are readily subjected to political influences, as many of them are often elected or directly appointed or serve shorter terms. In federal court, the jury pool is often drawn from a larger and more diverse district. The rules of jury selection are much more robust than in state court. This helps to ensure that the political biases of one locality do not improperly influence the jury and its decisions. So we must ensure that state courts are not weaponized against current or former presidents, vice presidents, or U.S. officers. This is common sense. We can and should act to provide this option of a fair playing field for legal proceedings for all presidents, vice presidents, U.S. officers, former and current. I urge support, and Mr. Chairman, I yield back.
The gentleman yields back. We now recognize the ranking member for his opening statement.
Mr. Chairman, thank you very much. So the legislation before us today would amend the law so that a president or vice president, or even a former president or vice president, can remove any state civil or criminal prosecution when that case is brought, quote, for or relating to any act while in office. Okay, any act, whether it's public, private, official, unofficial, within the core functions office, within the outer perimeter, or having nothing to do with the office at all, for any act while in office, or where the state court's consideration of the claim or charge may interfere with, hinder, burden, or delay the execution of the duties of the president or vice president. In other words, every conceivable case will be removable. So look what we're talking about. And I hope my Republican friends will listen as well as the Democratic members. We're talking about destroying state criminal jurisdictional authority and power over federal officials. That's really what this bill is about, because it's saying that the president or vice president or former president or VP can never be prosecuted because, of course, it could conceivably hinder the execution of their office. Of course, it's any act, one office. So what we're talking about is, should a president or vice president ever, or former, ever be able to be charged with a state crime, including assault, rape, murder, fraud, you name it. And they're basically saying no, that has always got to go to the friendlier terrain of a federal court. So let's remind ourselves of what the genesis of all this is. On May 30th of last year, Donald Trump was convicted in New York State Court of 34 felony counts for falsifying business records to hide his hush money payments to women who he'd had an affair with. When he tried to have the case removed to federal court, the judge found that, quote, hush money payments were private, unofficial acts outside the bounds of executive authority and thus not subject to the constitutional removal requirements. It had nothing to do with his office, and the defense was not a federal defense. It was just a conventional alibi defense that you would find in the normal course of things in a state court. Trump also has charges pending against him in Georgia state court after Trump called the Georgia Secretary of State, Brad Raffensperger, famously asking him to just find me 11,780 votes. He was charged with election subversion and racketeering under Georgia law. He withdrew his application to remove his case to federal court after his co-defendant, our former colleague Mark Meadows, was found not to have met the quite low threshold to move his case to federal court, and that the actions outlined in the indictment were not taken as part of Meadows' role as a federal official. In other words, there was no federal defense available, making this a federal question. Last time this bill appeared at a markup, candidate Trump was just starting his campaign. He'd not yet been convicted of those 34 felony counts. His co-defendants had not pled guilty. In 2023, this was simply a bill to get the cases against him out of state court and into the federal system, where Trump and his lawyers could try to shop for the judges they wanted. Today's bill looks very different because House Republicans have a new goal. They want to make sure Trump is not held to the same standards as anybody else, in essence, that he's above the law. My colleague's solution to Trump's personal legal problems, which were created by him, is not to make him all but untouchable in the American judicial system. This bill would require a federal court to dismiss any case against the president or vice president or former president or VP that becomes subject to removal, and that's any case in the state court system. The 2025 version of this bill is an autocratic Christmas tree designed to ensure that nobody in Trump's orbit, from Trump and J.D. Vance to Elon Musk and Mark Meadows, is held accountable in state court. That is completely incompatible with the idea that none of us is above the law. It's an assault on states' rights. It's an assault on federalism. It's incompatible with the Constitution, and it does not do justice to the hard-fought principle that nobody in America is above the law. I oppose this bill. I encourage my colleagues to do the same, and I will yield back to you, Mr. Chairman.
I thank the ranking member for his opening statement. The chair now recognizes the gentleman from South Carolina for the purposes of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1789 offered by Mr. Fry of South Carolina.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes the gentleman from South Carolina to explain his amendment.
Mr. Chairman, this amendment adds the year to the title of the bill, and it's not intended in any way to alter the substance of the bill. I yield back.
Who seeks recognition?
Strike the last word. Mr. Chairman,
I have the
I have an amendment at the desk.
I'm
Sorry, never mind.
we'll take the strike the last word first, if that's possible. The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. We discussed this bill yesterday in what we are hearing, and it made me think of critical race theory. Critical race theory is about educational, scientific, historical knowledge of the past, which some people think is disturbing because it disturbs them to think that we had slavery in this country, that we had Jim Crow for about 80 years, that we didn't allow blacks to vote forever unless they could count all the peas in a jar. So we got a critical race theory. We didn't like the idea that we killed so many Native American Indians and it was almost a genocide. We want to get rid of that too. This is critical law theory. The Republicans don't want people, and Donald Trump doesn't want people to know that he is a convicted felon. And he wants to find any way in the world to end that. And he wants to say, I didn't do anything wrong. I'm perfect. I'm the greatest guy in the world. Everything happens with me. He got convicted on 34 counts, felonies, by juries that every single juror said guilty, 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 guilty. Donald Trump is guilty, and no matter what you do with this law, he's guilty, and history will record it as such. But what you're trying to do is do his work to have critical law theory and to erase what is a fact in courts. The state court did it in Georgia because, yeah, that's where he called the governor and said, just find me 10,734 votes. I want to change Georgia's election. I want you to cheat in Georgia and get me some votes so I can have the votes to become president. That's a Georgia case. He was interfering with Georgia state election and Georgia state law to get Georgia's electoral votes. Should have been in state court. But no, Donald Trump doesn't want anybody to think he did anything wrong. So he wants to remove it to a federal court and maybe get it into a court, judge like Eileen Cannon, that'll go, yes, Mr. Trump, what you want? That's what they want. They want judges who have no guts, who have no respect for their oath of office, like Eileen Cannon, who embarrassed us with putting off the classified documents case, and who did, repudiated by the Court of Appeals. They found her actions to be sophomoric at best. These bills are absurd, and for us to be doing them shows us to be supplicants. We take an oath to support the Constitution. Yeah, we can change laws, but this is about critical law theory. Critical law theory. No, Donald Trump did nothing wrong. Donald Trump, in fact, should have been on the Supreme Court because he's smarter than everybody. He knows the law and never would violate it because he knows it better than any of us. Well, BS. I yield back my time.
Will the gentleman yield?
The rest of you.
Will you yield?
Yes, I yield to Mr. Goldman.
I thank the gentleman. I have a question for my colleague, Mr. Fry. If this is removed, if a state case is removed to federal court, what law applies?
Well, it's the state law, but the process is under federal jurisdiction. So we already do this for ambassadors, for members of Congress. That's how the current law exists as it stands. And so this would extend those the same federal statute to former members, or excuse me, former presidents and vice presidents, obviously.
Right. I mean, I think the law would still apply. The same federal question doctrine still applies. This bill is very clearly designed not to actually correct a problem, but to simply defend Donald Trump and perpetuate the absolute whitewashing that the Republicans have doubled, tripled, quadrupled down on in fealty to Donald Trump, that somehow these were political prosecutions and investigations. And the only evidence of that is that the defendant said it. That's all you have. You have no actual evidence of any politicization or weaponization.
Well, Mr.
If you look,
Sir,
I reclaim my time. If you look at the actual indictments, if you look at the Mar-a-Lago search warrant, there is not an objective judge, prosecutor, or anyone else who understands criminal law who would say there's not enough evidence to charge or to go forward with a search warrant. And all you are doing is trying to create a monarchy for Donald Trump. And that's what you have been doing by yielding all of your power to him for the last 6 weeks.
The gentleman's time has expired. I now recognize the gentleman from South Carolina.
Let me just write the last word.
The gentleman's recognized for 5 minutes.
Thank you. I was going to respond. You said that this was not, Mr. Goldman, this was not politically motivated, but we know that to be the case. In fact, you live in the jurisdiction of Alvin Bragg. You campaigned with Alvin Bragg, who campaigned on going after Donald Trump.
False.
So to say,
he never campaigned on going after Donald Trump.
To say
gentleman
that this
from
was
South
not
Carolina's
politically
time.
motivated is not based in reality. This absolutely was. There was coordination with the Biden DOJ. That was both in the Georgia case and the New York case. And so to say that it wasn't and that we're just making it up really kind of goes against the overwhelming evidence to suggest that that's exactly what they were doing to begin with.
Will the gentleman yield for a question?
With that, I yield back to the chair.
Would the gentleman yield for a question?
No.
To me?
To you, Mr. Chairman, of course.
So many questions, so little time. So there were a few things said, and I want to understand so that everyone understands. Currently, a federal judge whose a similar event occurs would be removed to federal court. Is that correct?
Correct.
And if there's ever been a friendly venue, it would be for a federal judge in a federal court. And yet that's been the law for a long time, right?
Correct.
And currently, if it were you or any of the gentlemen on the other side, it could be removed to federal court in many cases.
Correct. And again, it's not a mandate. It's an option that you could remove. And so it is up to the defendant in a civil or criminal case to take that option to remove.
And for those who haven't practiced in federal court, it is not uncommon for federal judges to be overseeing cases that include state causes.
Would the
correct?
gentleman yield?
For sure, yes.
Okay, so there's nothing unusual here. It applies to other federal offices.
Issa yield?
Just one second. We're extending it only to the president. Let me go through a couple of pieces of history, though, if I could, and ask you questions. President Obama ordered and struck an American citizen on foreign soil and killed him. You remember that?
Yes, Mr. Chairman.
Okay. Terrorist, but he wasn't currently shooting at us or anything like that. He was tried, I guess, in the international court, but we didn't recognize that. Nobody, picked a state where this terrorist was from and tried to prosecute the president. But if they did, without this law, isn't it conceivable that it wouldn't be removed to federal court and you could have a venue that somehow would think they could try the president for his official acts?
That's exactly right.
And the gentleman was referring, I think the ranking member was referring to this idea of dismissal. is there anything here that dismisses cases that is not consistent with the U.S. Constitution based on, or with the decision of the Supreme Court?
No, I think that goes beyond the bounds of the legislation. This is just a removal mechanism. This isn't a removal and dismissal mechanism.
Okay, now, not having been in district court all over the country, would this case be removed in the jurisdiction in which the state occurs? In other words, if it's in Georgia, would there still be a Georgia federal court hearing it? It wouldn't be removed somehow to Nova Scotia, right?
Correct.
Or Greenland?
Correct, Mr. Well, unless they're the 51st state.
Okay,
we'll
so
see.
just for people that haven't, served on a lot of juries, the pool of federal juries in Georgia is the same pool, whether it's state or federal, correct?
Correct.
So the same individuals would try. The only question is, do the ladies and gentlemen on one side of the aisle don't trust federal judges, but they trust local judges who run for office versus federal judges?
Right. Correct, and have all the potential for political influence based on donations, based on political party and the like.
Okay, so really all you're doing is removing it from the political process to an apolitical process and keeping it in the same geographic area that the case is brought, but removing it to federal court.
Correct, and if you, as an accomplished lawyer yourself, Mr. Chairman, you know that the jury selection in a federal system, the defendant or the plaintiff know much more about the potential jurors, potential biases, the potential to obviously strike those jurors. You want a fair and impartial jury. You know much more about those jurors in a federal system because the system is much more structured than in a state court. State court, you show up and the jury pool's there and you're oftentimes trying to use your best judgment on who would be a fair juror. And so this, again, gives the former president, the former vice president, the option to remove if they so choose.
And isn't the former vice president still limited to this provision of the interference? In other words, it's not everything. It's based on acts related that could, a former vice president acts relating to any act while in office. So it's not for life on former presidents, right? It's just for those for the acts while in office.
Correct.
I thank you, and thank you for yielding.
Thank you, Mr. Chairman.
Who else sees recognition? The ranking. You wanted to hit him?
I think everybody's gone. Are you?
At some point, I would like to move to strike the last word, but I defer to the ranking.
Out of deference to the ranking member of the full committee, I recognize him to strike the last word.
Thank you, Mr. Chairman. I'm just going to follow up on your line of questioning, and then we can go to Mr. Goldman. If the gentleman from South Carolina, if he could come back, if maybe someone could get him to, I would love to pursue the questioning. But here's where I'm going with this while they're getting him, Mr. Chairman. I think you asked exactly the right question. You were saying all this is a removal provision, right? But it's not just a removal provision. It's a removal and dismissal provision. If you look at E on page 5 of the bill, it says, in any action subject to removal under paragraph 5, which is current president or vice president, or 6, which is former, of section 1442A, such case shall be dismissed unless rebutted by clear and convincing evidence establishing that the continued pendency of the state claim or charge would not in any way interfere, hinder, burden, or delay the execution of the duties of the president or vice president. And what I'd like to ask the distinguished gentleman from South Carolina is, can he imagine any case where a president or vice president or formers would lose that in saying this is going to hinder or burden or delay my execution of duties? Who wants to be in a criminal prosecution of any kind? So it's a guaranteed removal and dismissal because it must be dismissed. It shall be dismissed unless you can prove it's not going to affect their life in any way.
Would the gentleman yield?
By all means.
I would agree that if you took it out of context, just looking at it here, but the context, I hope we all agree, this is a Supreme Court ruling. We're codifying what the court has already said. And as to a former member, which the president was when charges were brought, the standard would, by definition, be different because he wasn't executing his activities during those 4 years. So the actual dismissal of those cases—
Just reclaiming my time for a second. If that's true, then why should the logic of this apply to him at all? Why should it apply to former officials in any case?
Because the removal would apply, but not the basis to dismiss. That's where the two, as the gentleman probably knows, currently Prime Minister Netanyahu spends 3 days a week in court because they have no such law in Israel at a time in which he's defending his country in a war. We're seeking to make sure that we minimize to the greatest extent possible 50-plus places, states in which people could bring cases against a current president. And if they bring it against a former president for acts while in office, limited to acts while in office, that it simply be removed to federal court. But I think the Supreme Court decision on dismissal is very different for a former president because they don't meet that standard of hindering his execution of his job.
Okay, well, just to reclaim my time there, if we're talking about a former official, it shouldn't apply at all because they're no longer in office. In the New York case, Trump claimed that it interfered with his presidential duties, nonetheless. But look, I would say this. This shows spectacular disrespect for state courts, state constitutions, state prosecutors, and state law. I mean, I'm really shocked that this is even something we're considering to obliterate state criminal jurisdiction over crimes that exist within their state. And if they're, in some ways manufactured or invented, the state systems are just as capable of vanquishing the fantasy prosecutions as a federal court is, and much better at interpreting and enforcing state law than a federal court would be. And yet,
gentleman yield?
Yes, I would.
I just wanted to clarify, one of the gentlemen on the other side said that the state judges are elected. Some are, many are appointed, just like federal judges.
That's absolutely right. And so, I mean, this does reflect a basic structural trampling of state court and state legal systems. But I think that the really sneaky provision is this dismissal one, because the overwhelming presumption is that it will be dismissed the moment you get it into federal court, unless you can somehow prove that this will not in any way affect the performance of the duties of the president or vice president. And if they're no longer president or vice president, why are they getting the benefit of this in any way at all? So I do agree with Mr. Goldman that this seems like a very political bill that's just meant to curry favor with or perhaps soothe the hurt feelings of Donald Trump. He was in those situations because of actions he did. He was the one who said, just find me 11,780 votes. Nobody else made him do that. He made his staff go ahead and call Secretary of State Raffensperger. He was in trouble in New York because of the hush money payments he made, and then he cooked the books in New York. That was his decision. I mean, let's show some civic self-respect here and acknowledge that people are responsible for their own actions. I yield back to you, Mr. Chairman.
Thank the gentleman. Who else seeks
Move to strike the
recognition?
last word. I move to strike the last word.
The gentleman's recognized for 5 minutes.
Thank you. I want to just pick up on what the ranking member was saying, and a couple of things. First of all, this is not simply codifying a Supreme Court decision, nor is this removal for a federal court to consider a state law claim. And I would point my colleagues to page 4, section B1, for determination of immunity, saying the nature, elements, or any other aspect of the charge or claim made by or under authority of state law. Basically, any state law claim is immune. So it's not interpreting state law just simply in a federal court. If you want to bring a bill that simply clarifies that the rule for judges and members of Congress should be the same for federal official, the president and the vice president, we can discuss that. This is nowhere close to that. This is going even further than the Supreme Court case because it also addresses civil cases, not just criminal cases, and it also expands the immunity through both dismissal, as the ranking member pointed out, and there are other references to dismissal, but beyond what the Supreme Court says. But even more importantly, it goes so much further than what you're representing. And I would just urge my colleagues not to continually overreach in fealty to Donald Trump. We are happy to discuss thoughtful, reasonable legislation that preserves the rights of a president and a vice president. Why are former presidents and vice presidents even included in this?
Will the gentleman yield?
Yes.
I've got one theory about that, but I would love to be illuminated by someone on the other side of the aisle. But Donald Trump in the New York case was saying that even though he was no longer president, the fact that he had to stand trial interfered with the fact that he was running for office again and was involved in other political activities. So I think they put in former presidents and vice presidents in the event that they wanted to be running for some other office.
Right, and of course, if you expand that to its logical conclusion, every one of us is always running. Always running. So if the argument is, oh, well, you can't charge a elected official or former elected official because they're running for office, Donald Trump very clearly announced his campaign extremely early and previewed the fact that he was doing it so that he could argue that these investigations against him were interfering with this. This was a defense that he created, and then everyone on the other side of the aisle bought into it. But I do want to just answer my colleague from South Carolina on the New York case, which I would point out there was no assertion or allegation that the special counsel's two cases there was any evidence of politicization. He did not mention the Georgia case, so let's just focus on the New York case. Alvin Bragg never campaigned on getting Donald Trump. Never said, I am going to get Donald Trump, I am going to go after Donald Trump. Never. If you have a quote of his, please, I urge you to bring it to me. Never happened. False. Secondly, I don't know what coordination between DOJ and the Manhattan DA's office you are talking about, but I can tell you that as a federal prosecutor for 10 years, I spoke to state prosecutors all the time. We shared evidence all the time. That's how prosecutions work. Sometimes you will charge it in state court, sometimes you will charge it in federal court. But I don't even know what allegations you're talking about. I haven't seen any evidence, any actual support, other than the fact that a former DOJ official joined the prosecution team in the Manhattan District Attorney's Office. I don't understand how that is the DOJ coordinating. He's no longer with the Department of Justice. But you keep making these allegations and you have no support. And it's as if you say it enough times, it just becomes true. But that if you say it enough times, that doesn't mean there's any evidence to support what you're saying, and your allegations are baseless that any of those prosecutions was politicized. And I yield back.
I now recognize myself. I ask that that an excerpt from page 24 of an actual hearing, perhaps you weren't there in New York, but the quote is, let's talk about what's waiting for the new DA, the docket. We know there's a Trump investigation, okay? So here is the reference that came out of it. On March 17, 2021, Bragg indicated that if elected as district attorney, he, quote, will hold Trump accountable. Just a few days later, on March 23, 2021, he again boasted that he had sued the Trump administration over 100 times. In June of 2021, Bragg doubled down, stating that the important work that separate from any that the DA office may be looking at now. In other words, Bragg assumed office with seemingly one goal: to prosecute President Trump.
Will the gentleman yield?
I will in a moment. To say that this wasn't a determination, that he didn't cobble together misdemeanors to create a felony, that he didn't invent something that, quite frankly, had never been done before, that he didn't work around a statute of limitations, is laughable. Having said that, I'm going to, because the gentleman asked me to yield time for a question, I'm going to just ask one question. All we're doing is modifying federal law. Federal law in the state above that, because he kept quoting from 28 U.S.C. 1442, it applies to any officer of the courts of the United States or related to the act under the color of the office or performance of the duties. 4, any officer of either House of Congress or related to any act in the discharge of his official duties in the order of the House. Would the gentleman suggest that we strike both of those? Would the gentleman take away his own ability to remove or the judge's ability to remove? Because all we're doing is adding other federal officers and ultimately covering what I think is a branch not covered by this 28 U.S.C. 1442. Would the gentleman respond, please?
Yes, and as I mentioned to you, if that were simply all this was doing, I would be happy to discuss this in good faith.
Would the gentleman agree that adding the decision of the Supreme Court, and he did reference the basis for, on page 4 for the basis of immunity, and reading it carefully, I think the gentleman will find that what it actually does is that it states that for purpose of determining the immunity, you will not look at the nature of the charge. And the gentleman did say, what about murder? Well, the question for it would be, was it official act? And I cited President Obama's murder, ordered execution of an American citizen without a trial or a grand jury or any other indictment for actions. The fact is, a state court could have brought charges for that. In this case, it would have been removed. The court would have decided that, in fact, the commander-in-chief made that determination and he had immunity. I'm not disagreeing with the court. What I'm saying here, and Mr. Fry's bill clearly says, is it's to be considered in federal court, and the immunity question is not a question that is automatically dismissed.
Would
It's
the
a case,
gentleman yield?
yes, I will, consistent with the Supreme Court ruling, yes.
I'll defer to Mr. Nadler.
Thank you. What President Obama did was an official act. If what President Trump was convicted for was not an official act, if anyone at this table, in this committee room rather, violated the state law by committing murder or by theft or by fraud, he'd be tried in the state court.
I agree with the gentleman that the allegations were not an official act. However, you'll notice in this Mr. Fry's legislation, the removal has to be for an official act to be removed for a former president or vice president.
Not for the president.
No, not for the current president, but for a former president. In other words, the discussion about what President Trump wanted removed during his campaign. Under this, it doesn't change the removal during that period in which he was a former president.
He would have, under this bill, as a former president, the local prosecution would have been removable. Under current law, it is not removable, nor should it be. A violation of state law should be prosecuted at the state level.
I think we just disagree on that. Who else seeks recognition? You've already seen.
I think I've already spoken.
Yep. Mr. Johnson?
Thank you. I yield to the gentleman from New York.
Thank you to the gentleman from Georgia. Mr. Issa, the Constitution applies to state courts as well as federal courts. So the Supreme Court's opinion applies as to official acts in state court just as it would in federal court. So I don't understand what your concern is about the application of the Constitution when that also applies to state court. And I would just say, Mr. Issa, in response to the quotes that you read, saying that I sued Donald Trump previously is not saying that I am going to indict him. And in fact, the investigation that was currently, that was at the time alive, was not the charge that was ultimately brought. In fact, Mr. Bragg refused to bring the criminal case that was under investigation. The line prosecutor who was investigating that case resigned in protest over the fact that Mr. Bragg did not charge President Trump with that investigation. So those quotes that you're talking about in the ongoing investigation that is referenced there was ultimately not brought by Mr. Bragg. So you can have complaints about what the actual charges were, and I think there are reasonable arguments to, to debate about the discretion, but it certainly was found by a jury to be a conviction. The president will have his appellate rights. He may appeal it, and if your allegations about converting a misdemeanor into a felony and statute of limitations and all that stuff are true, then a court would agree with you. But we already have the proper system to be able to deal with that. And so I think on both scores, you're missing the mark here. Again, if you want to go back just to say presidents and vice presidents should also, 1442 should also apply, let's discuss that. But that's not what this bill does.
Would the gentleman, oh, go ahead. Okay.
Yield to the gentleman from New
I just
York.
wanted to pursue two other critical points of textual meaning. The good chairman suggested that when it comes to a former president or vice president, that would apply only to public acts and not private acts. There's nothing in the language of the bill to suggest that. On the contrary, it says a former president or vice president for or relating to any act while in office. And if that is to mean any public act, then there should be an amendment to that effect. But right now, it would apply to an assault, a rape.
Would the gentleman yield?
Yes, I will.
If you look at page 5.
I'll yield to the gentleman
line
from New
10,
York.
It says, no court may define or limit the scope of the duties of an official of the executive office of the president. So
And that's where I'm going right now. Thank you, Mr. Nadler. That's the other point that's so critical. And I was hoping that, Mr. Fry is back. Mr. Fry, could you, if you would yield just for a quick question, what was your intention when you drafted that language on page 5 on prohibition on limitation of scope? No court may define or limit the scope of the duties of an official of the executive office of the president. I have some questions about that.
I'm sorry, re-ask that again. I'm trying to find the page you're referencing.
If you go to page 5, D, prohibition on limitation of scope, no court may define or limit the scope of the duties of an official of the executive office of the president. But just while you catch up here, look, here's what I'm concerned about. If you read the court's decision in Trump versus United States, the way it's structured is this, that there are core functions of the president where the president is automatically, absolutely immune from criminal prosecution, like the exercise of the pardon power. Then outside of that, the powers of the president are described as official acts that might not be core functions. And there, he's presumptively immune, and it becomes a balancing operation to look at the public interest versus the president's interest. But outside of that, it's non-official private acts, presumably things like rape, sexual assault, murder, theft, fraud, where the president is treated like everybody else in that third tier. But here it says no court, that would presumably include the Supreme Court, may define or limit the scope of the duties of an official of the executive office of the president. So I just want to know, does that obliterate that tripartite taxonomy that we get from Trump versus United States? And does the president himself constitute an official of the executive office of the president?
Look, I think at the end of the day, state courts should not be defining what an official act of a federal official or former federal official should be.
But this says no court, so you would amend that to say no state court.
State courts. No. But state courts, where we are at with these cases that you guys are referencing, is that state courts were deciding what this is. And
No, I know, but I'm just asking about the language of your bill. When you say no court, do you there want to say no state court? Because we can amend it to say that. But right now, this would say no court, including the Supreme Court, can limit the definition of the duties of the president. And that would seem to overturn that tripartite analysis coming from, okay, well,
All right, gentleman yields back. Who seeks
Mr. Chairman.
recognition? Gentleman from Kentucky.
I move to strike the last word.
Gentleman is recognized.
I'd like to yield time to Mr. Fry.
Gentleman is recognized.
I thank the gentleman for yielding, and I think it was discussed earlier that this was not about politics and that people campaigning for district attorneys were not campaigning on going after the former president, now current president. But that, of course, is belied by the evidence, and I think we have a video to show just that.
Whoever has this job, are they going to convict Donald Trump?
Look, that is the number one issue. I'm the candidate in the race who has the experience with Donald Trump. We sued the Trump administration over 100 times.
I sued Trump over 100 times and brought a case against the Trump Foundation and held him accountable. Holding Trump accountable for the Trump Foundation.
From exposing illegal behavior by the Trump Foundation.
I do have a lot of experience with the former president. I led the New York State Attorney General's work and investigation and successful litigation against him and his family for their misconduct with the Trump Foundation. And also we had a number of litigations, more than 100 involving the Trump administration. I led the team that held Trump and his children accountable for their misconduct with the Trump Foundation. I oversaw the work which sued his administration more than 100 times. I led the Attorney General's work on the Trump Foundation case where we held Trump and his family accountable. When I was at the Attorney General's office, I led our work on the Trump Foundation matter.
I also led the team that did the Trump Foundation case, and I've seen him up front and seen the lawlessness that he can do.
Started out as a civil rights lawyer, then became a federal prosecutor, ultimately was the #2 lawyer in the New York State Attorney General's office, leading the charge against the racist policies of the Trump administration.
I believe we have to hold him accountable. I've litigated with him, and so I'm prepared to go where the facts take me once I see them and hold him accountable. Being a rich, old white man has allowed you to evade accountability in Manhattan. That includes Trump and his children, right? We held him accountable in the Trump Foundation case. My office did the Trump University case. So I've seen a pattern of lawlessness over 20 years. And so I'm inclined to believe all I see in the public domain and know that there's, and believe that there's a path forward there to make a case.
So I think we go back to the basic premise of the bill, is that you have a prosecutor in New York who's not worried about crime in New York, Manhattan. He is worried about going after the former president of the United States. Why? Because it earns him political points in a jurisdiction that did not vote for Donald Trump. And so they elected this guy to go after him, despite the fact that there are other crimes that you could be going after, but resources are dedicated. And so to sit here today and say that this has not been about politics, this is about fairness in the system, it's total BS to believe that that is actually the case, because he said it 1,000,000 times on television. He campaigned on it, and that is the purpose, one of the huge purposes of this bill, is to remove that from a fairness perspective, that a jury in a federal system, that a different system that is not rigged in a state court can go and have a fair trial. The presumption of innocence is on a criminal defendant, and if we do this for ambassadors, if we do this for sitting presidents right now, why would we not extend that to somebody when they are targeting a former president or vice president?
Will the gentleman yield
for political
for a
points?
question?
And with that, no, I yield back
Gentleman declines yield.
to the chair, or to the gentleman from Kentucky.
Gentleman yields back. Gentleman from Kentucky.
Will the gentleman from Kentucky yield?
I yield back to the chairman.
All right, gentleman yields back.
Very unfriendly over there.
The gentleman from New York.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, what we saw was Alvin Bragg talking about how he prosecuted, as an official, I think in the AG's office, Attorney General, he prosecuted the Trump Foundation. Well, the Trump Foundation, let me read you a headline from December 10th, 2019. Donald J. Trump pays court-ordered $2 million for illegally using Trump Foundation funds. The courts also found that Trump University was a fraud. The court also found, a separate court also found that Donald Trump sexually abused E. Jean Carroll, and the judge said that's the technical term, but most people would consider that rape. So the fact that Alvin Bragg brought up some of these prior actions which he had been involved in and which Trump had been involved in when he was a private citizen shows nothing other than that Alvin Bragg was a proper prosecutor. And remember what he said on that video. He said, "I'm prepared to go where the facts take me." That's what a good prosecutor should do. And that's what Alvin Bragg did. And the facts took him to a hush money prosecution in which the former president was found guilty on 34 counts. And most of that was done while he was not president. The only reason that this bill comprehends that he did anything while president is that some of the hush money checks were written while he was president after the fraudulent scheme had basically been completed. This shows nothing but that Alvin Bragg is a proper prosecutor, took the facts where he wanted, took the cases where the facts indicated, and in fact, he was very reluctant to prosecute Trump. His predecessor, Cy Vance, had initiated that. He had stopped it and then decided a year later that the facts warranted reopening the case. And now I'll yield to Mr. Cohen.
Thank you. Yield for question.
Yes.
He said something that he prosecuted or investigated Trump and the Trump Family Foundation. Can you refresh my recollection about what the Trump Family Foundation did and what happened to them?
Well, they were found guilty. They were forced to pay $2 million. I don't remember exactly what they did, but they committed a fraud for which they had to pay $2 million.
Was that the foundation that bought pictures of Donald Trump and they kept them in the Trump family and used the foundation funds?
Yes.
Was it the same foundation that maybe gave a contribution to Bondi in Florida, $25,000?
I don't know.
Yield to Mr. Goldman.
I'll yield to the gentleman. I'll yield to the other gentleman from New York.
Thank you. Yes, you are correct. And the board members of that charitable foundation were denied from ever being officers for a charitable foundation in New York again. And that was a previous case. That is a fact that I guess Mr. Bragg was involved in that case. And I think what undermines this whole argument of politicization is what I mentioned before. I don't know if Mr. Fry was here, but the investigation that was ongoing that he referenced, I've seen the public reporting, and based on that, I will follow the facts and I will hold him accountable. He followed the facts and declined to charge that case. If he was so intent on going after and getting Donald Trump, why would he overrule the recommendation of a very experienced prosecutor who came into his office solely to investigate that case, spent over a year investigating the case, recommended so strongly to charge the case that he wrote a whole book about it afterwards, after he resigned? I just don't understand how you can say that that was political when what he did is exactly what he said he was going to do and follow the facts, and he declined to charge the case. So stop making stuff up to suit your narrative. I yield back.
And I yield back.
Gentleman yields back.
Mr. Chairman,
Does anyone else seek recognition? Gentleman from Georgia.
I have a unanimous consent request for an article out of PolitiFact, which is entitled, "Here's What Manhattan District Attorney Alvin Bragg Said About Donald Trump During His DA Campaign," which was that he would continue his predecessor's investigation and hold Trump accountable by the facts where they go.
Without objection. Does anyone else seek recognition? The gentleman from Maryland.
Mr. Chairman, thank you. I've got an amendment at the desk.
Clerk will report the amendment. Gentleman from California reserves point of order.
Amendment to the amendment in the nature of a substitute to H.R. 1789 offered by Mr. Raskin, page page 5, line 11.
Without
insert.
objection, the amendment considered is read, and the gentleman is recognized to explain his amendment.
Mr. Chairman, thank you. This follows up on the colloquy that I had with the good gentleman from South Carolina. I think it saves at least part of the constitutionality of the bill. It says that no state court may define the scope of the duties of an official of the executive office of the president. Without that qualifying adjective, Mr. Chairman, I'm afraid that it renders the whole bill totally unconstitutional, because it's saying that the Supreme Court itself cannot define the scope of the duties of someone in the office of the president. And of course, that's what Trump versus United States did in assigning, absolute categorical presidential immunity to the president, acting within the scope of the core functions of his office, presumptive immunity subject to a balancing test within the outer perimeter of official acts of the office, and then extending no immunity at all when it comes to private acts. But this provision would, I think, whether deliberately or inadvertently, destroy that three-part analysis and say the Supreme Court can't define the scope of the duties of the president or anybody else in the president's office, as the gentleman said. So I think to salvage the constitutionality of it, we need to say no state court can do that, because under the Supremacy Clause in Article 6, the Constitution and the laws adopted in pursuance thereof are the supreme law of the land. And as the Supreme Court put it in Marbury versus Madison, it's emphatically the province and the duty of the Supreme Court, of the Judiciary Department, to say what the law is. And so this is an attack not just on Trump versus the United States, but on Marbury versus Madison. So with that, I would submit it to the wisdom of the committee, Mr. Chairman.
I'm recognizing myself. I know that this is well-meaning, but I must reluctantly oppose it because essentially by inserting this, what's happening is it implies that the federal court can in fact determine orders of the president to his staff and others would in fact be definable by the court rather than all of it flowing back to the same standard as the president. The president's use of people, whether confirmed or unconfirmed, but his use of people in his official acts are an extension of him, as we can imagine. We would certainly know that if he asked an attorney general to do it, we understand that.
Would the gentleman yield?
Just a moment. But if he asked his chief of staff to do it or somebody else that is not confirmed, this would neuter that. So for that reason, in its current form, I cannot support it, and I would yield to the gentleman from New York.
Mr. Chairman, if the President of the United States robbed a bank or committed murder or any other crime, under this bill, no court, the way it's written, no court can define the scope of the duty, so that can be held as official action if he says so, because no court may define what the official acts, what the duties are.
Reclaiming my time, under Article 2, those are not, the murder is not within his official duties. Robbing a bank is not within.
But if
So the court would still, and a gentleman's point is good, but the court would still, we're not stripping the court of its ability to interpret Article 2.
With all due respect, the language of this provision, D, does exactly that. It strips every court. And that's why Mr. Raskin's amendment saying no state court may do it makes sense, because otherwise you're saying that no court may define a crime as not part of the duties of the president, for which he is presumptively immune.
Yeah, I appreciate the gentleman. This is, you know, you're right in one sense. If the president robbed a bank under this, it might get removed to federal court. If he did it in concert with his chief of staff, it might get removed to federal court. But it wouldn't change the fact that he still would be eligible to, under the standard of Article 2, he still would be dealing with bank robbery. So there is no dismissal. And I'm going to use my time briefly just to get things maybe back to where I'd hoped they would be and would continue to be. This legislation is not about the current President of the United States. This legislation is about past and future presidents, vice presidents, and I would hope that in the spirit of really looking at this, we would all put our shoe on the other foot for a moment and say, whether it's a past president that we've all served with in the case of those at the top of the dais or a future president, all we're really doing here is trying to fairly come up with a standard that will work going forward. The history of the last few years shows that we can tie up a current or former president in courts and run them all over the country, all over the state, to multiple states. And if it was done in 50 states or 20 states, it could be even more dilatory. What we're trying to do is simply do the same thing that we in Congress enjoy, which is not to have our official acts impeded, particularly during that tendency of our presidency.
Would the gentleman yield?
I will in just a second. For that purpose, I would ask that people consider for a moment substituting the name Biden, the name Harris, the name Obama, or the name Bill Clinton, and ask if this were in place and we were using this for other presidents and vice presidents, would it really be that unfair, or is it a standard that we, over the long run, would be better for our republic? The gentleman from New York.
Yeah, I would simply point out that under the Supreme Court decision in Trump versus U.S., the current president is immune from anything. But a former president ought to be subject to the law like anybody else. And if he has done things that subject him to prosecution, he ought to be prosecuted.
And I couldn't agree with the gentleman more that we want there still to be a day in court. This bill does seek to limit it to make it appropriate for his official acts while he was in office, or she, a former vice president or president, to be held in federal court. And that's all we're really trying to do. With that, my time has expired. Who else seeks recognition? Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chair. I yield to the ranking member.
I thank the very distinguished gentlelady from Vermont. I think we're getting somewhere now, Mr. Chairman, and so let's take the personalities out of it completely, all right? So forget about Biden, Trump, everybody. Let's just talk about what the law should be in the United States of America. So let's recapture Mr. Nadler's bank robbery hypothetical, okay? So a president robs a bank in the state of California. We'll go to your home state, okay. And he's prosecuted. Now, under the language of this bill, he can go in, if you look at page 2, in section 5 here, he can go in and say, one, that this act took place while I was in office, so I should be able to remove to federal court, one. And two, I've got a second reason, it's going to interfere with, hinder, burden, or delay the execution of my duties. So, if this law is constitutional, and I don't think it is, but assume it was constitutional, he gets into federal court. Now in federal court, he moves from the removal provision to the dismissal provision. And what happens there? We'll go to page 5 of the gentleman's bill, where it says dismissal, okay? In any action subject to removal, such case shall be dismissed unless rebutted by clear and convincing evidence establishing that the continued pendency of the state claim or charge would not in any way interfere, hinder, burden, or delay the execution of the duties of the president or vice president. And this is also a former president or vice president, okay? So, but the president or vice president obviously wins on that. Who could say that having a criminal bank robbery prosecution, which has now been removed from state court to federal court, would not interfere with the execution of that president's duties? And so this is a way to completely obliterate the existence of the crime and the criminal prosecution and the state criminal jurisdiction, and here even federal criminal jurisdiction. And then if somebody says, well, wait a second, that's not fair. This had nothing to do with the president actually executing the duties of office. This is something that under Trump versus Anderson was in that, or rather in U.S. versus Trump, was in that third category. It was not, it was neither in the core functions of office, nor was it another official act outside of the core functions, but it was something completely private. the president, woke up in the middle of the night and went and robbed a bank or committed, wire fraud or whatever it was. And now, if you look at the provision right above dismissal, it says, no court may define or limit the scope of the duties of an official of the office of the president. In other words, it's not up to the court to say that was a private act. That was a criminal act. In other words, what the federal law was following the U.S. versus Trump case has now been vanquished. And what do you know? It's a get-out-of-jail-free card for a president to commit any crimes at the state level. So I am totally with...
The gentlelady yield for 1 second?
As long as you call me the gentleman, that's cool with me. So,
I said gentlelady because she has the time.
The gentlelady.
Oh, that gentlelady, okay. I will yield back to the gentlelady, yes.
I just wanted to point out that everything Mr. Raskin says is applicable not only to current, but to former presidents. So a former president who committed bank robbery would still have his case removed to federal court and would not be subject to the laws of the state for no good reason at all. And I yield back.
But all I would say, Mr. Chairman, with complete sincerity and honesty, is let's pull this bill. It's an absolute monstrosity. I think it's an embarrassment for any member of Congress to be voting for this. And I will yield back to the gentlelady.
And I know. Oh, you yield to me? Okay. Look, I certainly think that we can go back and forth on some nuances of the meaning. And unfortunately, we are playing, in my opinion, a little fast and loose with the difference between current and former, because the intent of the bill and the words as I read them do limit the benefit to a former president or vice president in consideration, because a former vice president does not have the standing to say it's interfering with his current official duties. And using the example of a certain former president, he did not prevail on the question of his campaign. Having said that, I believe that as we go through this, that if we go back to putting the hat back on and saying, is this good going forward, or should we strip away from the federal judges and ourselves the current and similar immunity that is in the underlying statute? And I thank the gentlelady from Vermont. Who else seek recognition? The gentlelady from Wyoming.
Thank you. Article 2 of the Constitution states that the executive power shall be vested in a president of the United States of America. In other words, it is the president that defines the executive branch. When you read this language, it says that no court may take over that role. No court may define or limit the scope of the duties of an official of the executive office of the president, the people who work in the executive office. I think that what your amendment does is a violation of separation of powers, and it's a violation of Article 2 of the Constitution.
The gentlelady yield?
Yes, I will.
It's always good when the constitutionalist specialist comes in. It helps us all. So what you're saying is that the bill codifies Article 2 for purposes of the court being reminded and instructed of their limitations, and the amendment would undo that.
That's exactly right, because then it would imply that a federal court could in fact define or limit the scope of the duties of those individuals who work within the executive office of the president, and that is not a federal court's role. That is for, under Article 2, Section 1 of the Constitution, that power is vested in a president of the United States of America.
Could the gentlelady further yield for another question?
Yes.
Your understanding is, with the current president, or the last one, or the next one, if we don't do something like this, realistically, the chief executive, president, would continue to have to answer a myriad of claims in up to not just 50 states, but multiple places in 50 states. And if that tactic was used, even more so than it may have been used in the past, that you would have a president having to use non-official funds to answer a series of cases alleged not to be that way. Is that true?
That's the way that I read this, and I think that it's very clear, especially starting in 2017 when President Trump was sworn in the first time, that the courts have been used for nefarious purposes on a variety of issues. In fact, yesterday we had a hearing in our constitutional subcommittee about lawfare and how lawfare had been weaponized against President Trump, both while he was president as well as after his presidency. So again, I guess that I'm very skeptical of the idea that people are not willing to use lawfare to go after a current or former president. We've seen it over the last 9 years in many different instances. But the president is the one who gets to define the limit and scope of the duties of the personnel within his office. That is very clear from Article 2 of the Constitution.
Will the gentlelady yield for a question on that?
Yes.
But I assume you've read the Chief Justice's opinion in Trump versus United States. And if so, are you saying that this decision was wrongly decided in distinguishing between core functions of the president, where his discretion is indeed absolute, as you suggest, the official acts that are not within his core functions, where Chief Justice Roberts says that's subject to a balancing test, and then private and unofficial acts where he doesn't get to define it all, that's up to the court?
We're not talking about immunity. We're talking about something entirely different. It's about who gets to define, who defines, and I think—
But that's precisely what they did with respect to immunity.
It's the gentlelady's time.
Okay.
When you read the decision, they did not strip the president of the ability to define or limit the scope—
Yes, they did.
The duties of the personnel within
They
his
said
office.
if it's private and unofficial, the court will know it. And that's exactly what this is about. If you rob a bank, you can't say that's part of my duties because I'm trying to reform the CFPB.
And that's not what he's saying. When you're defining or limiting the scope of the duties of an official within the executive branch within the official of the executive office of the president. All we're trying to do is prevent the violation of the separation of powers, as I've indicated. And
No, you're trying to strip the court of substantive jurisdiction over the president's powers, and you can't do that. It's emphatically the province and the duty of the Judicial Department to say what the law is, including over the president.
That is not what this provision says.
Well, if it does, what does it say then? What does it mean to say no court may define or limit the scope of the duties of an official of the executive office of the president?
The executive office, the president has the ability to define the scope of the individuals that work within the scope and the duties of the individuals that work in his office.
So that could include criminal actions.
That is not for a state court or a federal court to define.
So that could include criminal actions.
That is absolutely an absurdity to even
Well,
make
then
that
you're not
allegation.
reading Chief Justice Roberts' opinion. That's what it's all about. How do we constrain executive power? And you're saying you can't constrain executive power because the executive power is vested in the president. But that's a tautology. But that's just a tautology. The legislative power is vested in Congress, but that doesn't mean we can do whatever we want. We can't violate people's rights.
The gentlelady's time has expired. Who else seeks recognition? Seeing none, the question is on the amendment to the amendment in the nature of a substitute. Oh, I'm sorry. By the gentleman from Maryland. All those in favor say aye.
Aye.
All those opposed, no. In the opinion of the chair, the noes have it. The noes have it. The amendment is not agreed to.
We have a recorded vote on it, Mr.
Recorded vote being ordered. The clerk will call the roll.
Mr. Jordan? Mr. Issa?
No.
Mr. Issa votes no. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal, Mr. Correa, Ms. Scanlon, Mr. Neguse, Ms. McBath, Ms. Ross. Ms. Ross votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Garcia. Mr. Garcia votes aye. Ms. Kamlager-Dove. Ms. Kamlager-Dove votes aye. Mr. Moskowitz. Mr. Moskowitz votes aye. Mr. Goldman. Mr. Goldman votes aye. Ms. Crockett. Mr. Fry, you're not recorded. Mr. Fry votes no. Ms. Jayapal. Ms. Jayapal votes aye.
The clerk will report.
Mr. Chairman, there are 11 ayes and 14 noes.
The amendment is not agreed to. For what purpose does the gentleman from New York seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report. Gentleman reserves a point of order. The clerk-
Amendment to the amendment in the nature of a substitute to H.R. 1789.
Without objection, the amendment shall be considered as read, and the gentleman from New York is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I am offering a very simple amendment, one that should not be controversial. It would exempt from this bill a crime for which we arrest, imprison, and even deport people every single day: fraud. The American people deserve to understand what this bill from the majority is really intended to do. It is a blatant, shameless attempt to protect a convicted felon, Donald Trump, who is indicted in over 90 criminal charges across multiple courts. Last year, in my home state of New York, the nation watched as Trump became the first former president to be convicted of felony crimes. In the end, he was convicted on a whopping 34 felony counts related to a hush money scheme to cover up an affair with an adult film star and illegally influence the 2016 election. I believe we have a video from the day he was convicted.
We've got a verdict. Ari Melber.
We are looking at count 1, guilty. Count 2, guilty. Count 3, guilty. Count 4, guilty. Count 5, guilty. Those are the first 5 counts coming out of this jury, finding Donald J. Trump guilty on the first 5 felony counts. Reading the rest as we are getting it from our court reporters.
Starting with count 6.
Count 6, guilty. Count 7, guilty. Count 8, guilty. And you'll see on the screen we're tracking ahead. Count 9, guilty. Count 10, guilty. Count 11, guilty. Count 12, guilty. Count 13, guilty. Count 14, guilty. Count 16, guilty. Count 17, guilty. Count 18, guilty. Count 19, guilty. Count 20, guilty. Count 21, guilty. Count 22, guilty. Count 23, guilty. Count 24, guilty. Count 25, guilty. Count 26, guilty. Count 27, we're seeing that on screen, guilty. Count 28, guilty. Those are the first 28 felony counts here as read by the jury. Count 29, guilty. Count 30, guilty. Count 31, guilty. Count 32, guilty. Count 33 and 34, guilty. That is Donald J. Trump, defendant in New York versus Donald Trump, found guilty on all 34 felony counts. That is the verdict here in this case.
I believe, as you can see, in the interest of time, we sped up the tape to get through all 34 guilty verdicts quickly. However, those 34 felony convictions aren't the only legal challenges Trump faces in New York. Last year, New York Attorney General Tish James caught Donald Trump red-handed in one of the largest fraud schemes in state history. He was found liable for civil fraud and ordered to pay over $350 million, an amount that with interest now exceeds $500 million. What was the nature of this fraud? Years of deceit, scheming to inflate his wealth on financial statements, misleading banks and insurers, and manipulating accounts to maintain the illusion of being wealthier than he was. This was not merely a clerical error or misunderstanding. It was a calculated, deliberate fraud. Currently, Trump is appealing that case in state court. However, I imagine he would love for this bill to become law so he could remove that case from the New York courts, transfer it to federal court, and according to the provisions of this bill, seek to completely evade accountability. This is outrageous. Mr. Chairman, my Republican colleagues say they oppose a two-tiered justice system. But what do they call this situation? Why should a billionaire who holds the highest office in the land be allowed to evade accountability for crimes that would likely lead to imprisonment for any ordinary person? No one, whether it's the president or anyone else, should escape consequences for intentionally and immorally deceiving New Yorkers out of hundreds of millions of dollars. Republicans also claim to support states' rights. However, this bill would take away the ability of states to hold accountable those who attack and defraud their citizens. New York has the ability and the right to enforce New York crimes in New York courts. This bill should also be unnecessary. We have never had this issue come up for any other president in our more than 230-year history. Only now, because we have a convicted felon in the White House, do our Republican friends feel they need to change the law to ensure that Donald Trump will never again be held accountable in a court of law. Pathetic. I encourage my colleagues to vote against this underlying bill, but I hope they will at least adopt my amendment to ensure that states have the power to hold those accountable who attack and defraud their citizens. I yield back.
For what purpose does the gentleman from New Jersey seek recognition?
I'm going to make this simple, and
The gentleman is recognized for 5 minutes.
Thank you. We, had a very long meeting the last time on this committee. In fact, in our subcommittee hearing on oversight, we also had a very long meeting. So I'm going to do my best not to speak as much. It's hard to do, though. Let's just forget about the Trump thing and weigh the bill on its merits. And I would say to my friends on the other side, be careful what you wish for, because this is a theme we have in the subcommittee. If it happened to him, if it happens to a Republican, if it happens to a conservative, and when I say it, I mean weaponizing the judiciary, weaponizing the Department of Justice, it could happen to you as well. It could happen to any of us. Now, we all know that when it comes to this civil case, because that was the last case that my friend from New York spoke about, that clearly Letitia James was less fulfilling her role, her legal role, and more a political role. Clearly, there has been some cooperation between the Department of Justice in many of these cases, and I won't go through them all, and actually what happened in some of these cities and counties. And clearly, it's so obvious that this really could happen to anyone, and that these charges were blown up. Supposedly he overrated the value of his properties, et cetera, his wealth. All the banks that were involved in all these transactions to this day will say they're more than willing. They would love to lend him money again. He paid his money back on time when he was supposed to, the full amount, without any problems. Everybody knows, we're having the political argument here, but everybody I believe you should know that there is merit to this legislation, to Congressman Fry's bill. Everyone knows that we politicized the judiciary and the Department of Justice. And what I'm telling you is, life's a funny business. It's a cycle. And if it happened to him and it happened to us as Republicans, it could happen to you as Democrats. So let's clarify this and make sure that regardless of whomever is the President of the United States or the Vice President of the United States, that they are clearly able to function and do their job without fear.
Would the gentleman yield?
I will yield, yes.
Thank you. I would simply point out that regardless of the motives of Tish James, regardless of the motives of Alvin Bragg, which I think in both cases were fine, but regardless, juries found Donald Trump guilty in the financial fraud case and in the hush money case. And I will say that if any Democrat, current, former president, future president, non-president, is found guilty by a jury of his or her peers, they should pay the penalty. And Donald Trump is no different. Alvin Bragg, you may say, had bad motives. Tish James, you may say, had bad motives. I don't agree in either case. But separate juries, found Donald Trump guilty, and under our system of justice, that ought to be dispositive.
I'll reclaim my time. I understand your point, but the truth is, again, that this was a really difficult jury process there, jury selection, and that the Trump people had asked to have this hearing in another locale to move the jurisdiction, and they should have. And I'm not saying to a Republican area, but to a neutral ground. There was nothing neutral about this ground. I mean, we've gone through all this and we're not going to hash it out all again. But I'm telling you to really think about what I'm saying, to be careful. It was wrong what happened. It went from trying to get him through the legal system to trying even having secretaries of state pull his name off the ballot, which was clearly illegal and inappropriate as well. Folks on your side just didn't want him to run. Well, the way it works is he was nominated by the party to run a good election, fight hard, and see who wins. The way to stop a candidate from serving as president of the United States is not by misusing and weaponizing and politicizing the judicial system. So I ask you to think about it. I do not support this amendment, and I yield back my time.
The gentleman yields back. The gentlelady from Washington is recognized to strike the last word.
Thank you, Mr. Chairman. I think we have to be very careful when we start to question juries and the steps that lead to the jury system. I think all of this is extremely dangerous, and I think that right now...
Would you yield for 1 second, and I promise...
let me get through my comments, okay. And then I absolutely will. I think right now, House Republicans are doubling down on a very dangerous proposition, because this proposed bill codifies presidential immunity in 2 steps. It allows, first, any president to remove any civil or criminal case from state court to federal court related to, quote, any act while in office. And second, it establishes a presumption of immunity for any of the removed cases. And so the result is that not just Donald Trump, but any future president, and I would just turn it back to you and say, if you have a Democratic president, is this what you want? Any president is shielded, including Donald Trump, is shielded from civil or criminal liability for any violation of state law simply because he's president. We are not supposed to have kings in this country. And I want to take one of the arguments that Justice Sotomayor made during the Supreme Court discussion of presidential immunity. Imagine that President Trump, and you can substitute any Democratic and Republican name in here, but let's imagine that President Trump authorizes the military to assassinate Joe Biden, and that a local prosecutor brings a first-degree murder charge. Because the act happened, quote, while in office, Trump would be able to remove the criminal case to federal court. Then he would be able to assert immunity since the case was removable, and there would be no justice achieved. If that sounds extreme, it's because the bill is extreme. And I think when you ask us to apply it in a different situation, and I am going to try to give you a minute here, I think you have to think about, is this what you want? That's not where it ends. The bill actually even goes further than the Supreme Court did, because it expands immunity to all acts, including acts that have nothing to do with presidential duties. So here's another hypothetical example. Imagine that President Trump confiscates farmland to build a Trump hotel and golf course. Then a local prosecutor brings charges against Trump for larceny. And once again, because the act occurred, quote, while in office, Trump would be able to remove the state court case to federal court. And then when in federal court, he'd be able to assert immunity from criminal liability because the case was removable. I do think that one of the hallmarks of our democracy, if my colleagues on the other side agree with the principle of democracy, is that the president is not a king. The president is not a king, and yet it seems to me that my colleagues on the other side, intentioned or not, are doing everything in their power to make the president, not just this one, but any future one, a king. This bill, if enacted, would make him a king. So I'm going to yield to Mr. Van Drew, just so you can respond. Is this what you envision, that any president should be a king? In those examples, if I substituted Biden for Trump, and would you be fine with those things happening?
Thank you. I thank the gentlelady. I appreciate her viewpoint. Yes, I would be fine. I mean, federal court, inherently, there is nothing.
So Mr. Vandrew, so you are okay with the president having zero accountability, Republican president, Democratic president, zero accountability,
I'm not,
and being able to do anything they want, including murder, including appropriating farm. Our job is to take it to the hypothetical of the things that could happen. That's what we do when we pass legislation.
30 seconds. So, no, of course I wouldn't be all right. Nobody's saying that, and that would also, murder is a federal crime, can be a federal crime.
But he would have immunity according to this bill.
But we've never had this issue before, and the problem is that we now have prosecutors and attorneys general in various locations. And again, be careful what you wish for. Hypothetically, I'm going to be very open-minded here. It could happen where you had just the reverse situation. A very, very, very Republican state goes and sues a president or a vice president that's a Democrat. In fact, it well may have happened. And the other issue that I wanted to deal with real quickly is cases are moved all the time. So what they believe.
Mr. Vandrew, I'm going to reclaim my time because that is part of the process. They either get moved or they don't get moved. The determination is made. You either believe in the justice system or you don't. And what my colleagues have been doing is undermining the justice system over and over again and not holding the president accountable, giving him a free rein, or her, potentially in the future in this country, a free rein to do anything they want, I don't think serves our justice system. I yield back, Mr. Chairman.
The gentlelady yields back. Who else seeks recognition? The gentleman from California is recognized to strike the last word.
Thank you, Mr. Chairman. This is the simple, awful truth about the Biden administration. For the first time in American history, a presidential administration targeted its chief rival for criminal prosecution, concocted the most flimsy criminal charges, turned the federal law enforcement machinery against him, and colluded with Democratic state law enforcement officials to do the same. This is the historical record. This has happened. And when we speak of threats to democracy, what greater threat can there be than one party trying to jail its leading political opponent? For the first time in our history, a presidential administration executed an armed raid on a former and future president's home. For the first time in our history, the leading candidate for president was gagged by a rogue judge in the middle of a campaign. For the first time in our history, the leading candidate for president was pulled off the campaign trail in the middle of that campaign and compelled to sit through a grotesque mockery of a trial. My friend from New York, who seems to revel in the sham conviction that experts across the political spectrum, from Alan Dershowitz to Jonathan Turley, have all denounced as a glaring miscarriage of justice, if that analysis is confirmed by the higher courts, my friend from New York is going to spend the rest of his life having his words thrown back at him. The American people already...
The gentleman yield?
No. The American people already sat as the largest jury in history in 2024, and they saw right through the Democrats' corrupt abuse of our justice system. According to at least one poll, Americans reported they viewed the greatest threat to democracy as coming from the Democrats. And after all, what greater threat can exist to a democracy than a political party that sets aside the results of primary elections it doesn't like, gags its opponents, uses the FBI to strike down speech it doesn't like, and tries to jail its opponent on specious charges. The Democrats obviously lack any facility for self-reflection or self-awareness, as President Trump tried to remind them last night. How did that work out for you? You know, Bobby Kennedy asked, has there ever been an instance in all of recorded history when the people trying to censor dissent turned out to be the good guys? The same question can be asked of those who try to jail their political opponents. So my Democratic colleagues might want to take a step back and consider how history will judge them in the years ahead when passions have cooled and the facts remain. My father was a veteran of World War II, and when I was a child, the memories of that terrible epoch were still fresh. And He used to lecture us at the dinner table from time to time about midnight knocks on the door of political opponents, persecution of disfavored racial or political groups, suppression of speech, the perversion of the justice system, and the terrifying place where all of that leads. But every one of my father's lectures ended with these words: "Don't worry, that can't happen here because of our Constitution." Well, we've just lived through an era when that did start to happen. Our Constitution held this time. The people reasserted themselves. And it's now our responsibility to strengthen our laws to prevent us from ever starting down this dark road again. The absurd hypotheticals we hear from the Democrats give us some insight into their delusions involving Donald Trump. I'd simply remind them that Donald Trump never crossed the lines of civility and democracy that the Democrats trampled over these last 4 years. In the aftermath of this woke fever dream that we're emerging from, it's our responsibility to enact laws that make it impossible for our colleagues to ever again use the most fearsome powers of government to intimidate and obstruct and censor their political opponents. I yield back.
I move to strike.
Gentleman yields back. The gentleman from New York is recognized.
Thank you. My colleague who just spoke left one other first out of his list of firsts, which is that for the first time in history, a president tried to overthrow a lawful election, tried to incite a mob to invade the Capitol to stop the proper counting of electoral votes. That a president, for the first time in history, schemed and pressured officials all around the country to make up and fraudulently say that he won the election. That's also the first time in history. And while I know that my Republican colleagues have so much difficulty imagining the possibility that a Department of Justice could actually be non-political, because this Department of Justice and Donald Trump's first Department of Justice were so nakedly and brazenly political. But the point of having a special counsel is to remove the investigation from the supervision of the appointed Attorney General. Now, you may not like the special counsel regulations. You didn't like the independent counsel statute, which Republicans ultimately opposed. But the reality is that the Biden Justice Department also appointed a Republican special counsel to investigate Joe Biden for his possession and retention of classified documents. Now, I've heard many of my Republican colleagues create this false equivalency between the two because, of course, when President Biden found the documents, he immediately called the FBI to turn them over and sat for a 5-hour interview. When Donald Trump was informed that he had 15 boxes or more of classified documents, he hid them, he lied about whether he had them, he concealed them, he then lied again to the FBI about whether he had them pursuant to a subpoena, and ultimately the FBI learned that he was obstructing their investigation and he refused to turn over the classified documents. That is not the same as Joe Biden. But a special counsel is independent from the Attorney General, and other than your accusation, constant accusation, that the special counsel was appointed by the Biden Department of Justice immediately after Donald Trump announced that he was running for president, you have actually no evidence, no support for the notion that this was political, other than the fact that Donald Trump was a candidate for president, which, of course, he became so that he could use that defense. And if you look at the January 6th indictment and prosecution, as well as the others around the country, including guilty pleas by attorneys for Donald Trump who were trying to help him overturn the election, and if you look at the Mar-a-Lago classified documents case and that search warrant and that indictment, it is powerful and overwhelming independent evidence provided not by Merrick Garland, not by the Biden DOJ, not by the special counsel, by witnesses, by emails, by texts, by actual evidence. So if you're going to come and continue to make the baseless allegation that the Biden Department of Justice was politicized, then why don't you have some actual evidence to support those allegations? You guys had no problem interfering in the Hunter Biden case. You didn't like the plea agreement that he got. So members of Congress, the political legislative branch, wrote an amicus brief to a judge to object to a plea agreement. This was Biden's Department of Justice that was prosecuting his son. It's absurd. Just stop saying it. It does not add up that simply because you say it means it's true. Give me some evidence other than the fact that Donald Trump was a candidate for president, which he created himself to provide that defense. And I apologize to Mr. Nadler. I ran over time, but I yield back.
Gentleman yields back. I would just point out the court found that the case against Hunter Biden had problems in the agreement that they were trying to enter into. The chair
Yes, so that he wouldn't be prosecuted by Donald Trump.
I recognize the gentleman from Arizona.
Thank you, Mr. Chairman. What a convenient thing is selective memory. It's a convenient thing. We just heard that the first time this happened was all Donald Trump. But actually, the very first time in history, or at least in the last 50 years, that a presidential candidate attempted to thwart counting of electoral votes was in 2000 when Democrats in Congress attempted to decertify President Bush's victory over Gore. Then, in 2016, Democrats again attempted to decertify. That was Trump's victory over Hillary Clinton. And it wasn't the first time that a presidential candidate claimed that her electoral defeat was rigged. Hillary Clinton still thinks she won the 2016 election. She still thinks there was some kind of Russian interference that has been totally debunked. Hillary Clinton she's the poster child for claiming that Donald Trump's presidency was illegitimate. Yeah, so it is really a convenient thing, selective memory. You get to pick and choose what you want, which allows for forgiveness for your distortion of facts, which allows you to ramble on and create the narrative that you want to create. And my colleagues have the most remarkable thing. They have a collective selective memory. And they choose to ignore the realities. I support the underlying bill and oppose the amendment. I'm going to yield back to the chairman.
The gentleman is back. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I yield to the gentleman from New York.
I thank the gentleman. I want to point out a few things. After the 2000 election, after the 2016 election, some Democratic members of Congress objected to certifying the results. No Democratic senator joined them, so it was dismissed. But unlike 2021, no Democrat provoked a mob to attack Congress, to cause the deaths of police officers in order to stop the counting of the electoral votes. It is very different to object in the House, which is your right as a member, than to provoke an armed riot, number one. Number two, we have heard from our Republican colleagues today about the armed raid on President Trump's Mar-a-Lago estate. It wasn't an armed raid. That was the FBI executing a court warrant. And why was it necessary to get a warrant? Because Donald Trump refused to surrender classified documents. So they went to court and they got a search warrant, and the FBI executed the search warrant. Characterizing it as an armed raid doesn't change the facts. We're told that the Justice Department under Biden was weaponized against Trump, against Republicans generally perhaps. But let's take a look at that. Yes, a special prosecutor was appointed to investigate the riot, investigate Mr. Trump's role in the riot that attempted to stop the count of the electoral votes, and to investigate the the unauthorized retention of classified documents. A special prosecutor was also appointed to investigate President Biden's retention of secret documents, the difference being that President Biden immediately turned them over, and the special prosecutor therefore said, no problem. The special prosecutor, the Justice Department, I should say, was so weaponized against Republicans and for Democrats that it prosecuted the son of President Biden. It was so weaponized that it prosecuted a very prominent Democratic U.S. Senator, Robert Menendez. Mr. Chairman, this is not a weaponized Justice Department. This is a Justice Department doing its job and bending over backwards to do its job properly. And
Would the gentleman yield?
I will.
Are you referring to the current Justice Department?
No, I am referring to the Justice Department under President Biden.
Gotcha, thank you.
The current Justice Department, I'm glad the gentleman raised the point, is systematically identifying all the FBI agents who worked on the January 6th prosecutions, many of them by assignment, not by choice, and firing them. This is, talk about weaponizing a Justice Department. And the new head of the FBI has an enemies list, which he published. So, and as Mr. Goldman said, there is no evidence whatsoever that the Justice Department under President Biden did anything wrong, that Alvin Bragg did anything wrong, that Tish James did anything wrong, other than the simple assertion by Republicans that they did with no evidence to back it up whatsoever. I yield back.
Gentleman yields back. Oh, excuse me, it's gentleman from Georgia's time. That's right. Gentleman from Georgia.
Yield back.
Yields back. The chair recognizes the gentleman from Florida.
Thank you, Mr. Chairman. So I'll play like a little social experiment with my colleagues in the room. There's only like 5 of them here, but that's okay. We're light on members too. So I want to play this game because I just want to make sure I understand the point and that we're going to apply it evenly. So how many of you believe, and raise your hands, I mean, let's just get you on the record. How many of you believe Mike Pence should not be prosecuted for not listening to Donald Trump on January 6th? Should not be prosecuted. He shouldn't be prosecuted because he didn't listen to the president on January 6th. Right? Anyone want to raise your hand? No? So maybe Mike Pence should be prosecuted? That's potential. Okay, we got one. We got one member willing to say Mike Pence should not be prosecuted for not listening to Donald Trump on January 6th. Let's do Joe Biden. How many of you, by a show of hands, think, based on this, the law you want to pass, Joe Biden should not be prosecuted for anything he did in the Oval Office? Remember his dereliction of duty at the border? He should not be prosecuted. Let's get you on the record that he shouldn't be prosecuted. Nobody, no Republican wants to wave his hand. So fair game, Joe Biden could be prosecuted. So again, this is not about policy that you actually believe in. It's about settling the scores of what happened to Donald Trump. First of all, this is not going to get 60 votes in the Senate anyway, so this piece of legislation is dead, okay? And you don't even want to apply it evenly. You don't even want to apply it. Even Mike Pence, poor Mike Pence, could be prosecuted. And so, look, I'm not going to use all of my time because this is just a total waste of an exercise.
Gentleman yields back. The question occurs on the amendment offered by gentleman from New York. All those in favor say aye.
Aye.
All those opposed, no, no. In the opinion of the chairs, the noes, or opinion of the chair,
Mr.
the
Chairman,
noes
I
have
ask
it.
for a recorded vote.
And the gentleman from New York asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Groffman? Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Ms. Crockett? Mr. Massey, you're not recorded. Mr. Massey votes nay. Mr. Issa votes nay. Mr. Kiley votes nay. Ms. Scanlon votes aye.
Clerk will report.
Mr. Chairman, there are 8 ayes and 11 noes.
The amendment is not agreed to. Who seeks recognition? Gentlelady from Vermont.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report. Gentleman from California reserves point of order.
Amendment to the amendment in the
Without
nature.
objection, the amendment will be considered as read. The gentlelady from Vermont is recognized to explain her amendment.
Thank you, Mr. Chair. My amendment is pretty straightforward. It would exempt crimes related to sexual assault from being removable from state court to federal court. As we've talked about all morning, this bill before us would essentially grant a president immunity for any crime, even at the state level, through allowing him to remove all state cases to federal court where they would be categorically dismissed, including sexual assault and abuse. No one should ever get a pass for sexual abuse. I think it's especially important that we exempt sexual assault from the list of crimes a president can get a carte blanche for, because obviously sexual abuse is not an essential part of the duties of a president of the United States. And frankly, if a president abuses, he is seen as the most powerful man in the country. And it's critical that he be held accountable by a jury of his peers. 1 in 5 American women face an attempted sexual abuse or rape over the course of their lifetimes. Over 80% of American women, and over 40% of American men face some kind of sexual assault or harassment in their life. So what message does it send to women and girls and any crime victim if we sit here and tell them, hey, we're here for you, we're tough on crime, we're gonna hold people accountable, we'll go after your attackers, unless, of course, they are federal officials. Then they should get a pass. This is a chilling message to send to young girls and women across this country. We know that our colleagues across the aisle spend a lot of time talking about tackling violent crime. But it has become clear to me that they only mean violent crime committed by some of individuals perpetrated against other individuals that they deem more important. We should be doing everything in our power to protect these potential victims and not create carve-outs for their powerful and well-connected abusers. Every single member in this room right now can show solidarity with victims of sexual assault by supporting this very straightforward and simple amendment and telling women and girls across this country, and again, young boys and all the men who have also been sexually abused and harassed, that we see you, that we have your back, and we will do what we can to protect you no matter how powerful your abuser is. We can do this right now. This is straightforward. It is not complicated. You know, and I often think about what is my role in this committee? Because I am not an attorney, but it was important that we have voices in this room that are representing regular people back home that want to make sense of what we're doing or not doing. And they don't understand why something so straightforward like this, we can't even get agreement on. No man should be above the law. And when we're talking about sexual abuse and harassment, something that touches so many women in this country, so many families, so many communities that are shattered by this, it is unconscionable that we would imagine for a moment that it is right to essentially give a free pass to any elected official, and of course, a president or a vice president. We have a responsibility in this room to give voice to those Americans who can't be in this room, who don't get to sit in these seats, who want to understand that we actually have their best interests in mind. So I urge my colleagues on both sides of the aisle to support this amendment. It makes sense, it is the right thing to do, and I see no reason why anyone would stand in opposition to this amendment. I yield back.
Gentleman yields back. The gentleman from Arizona is recognized.
Move to strike the last word.
Gentleman is recognized.
Thank you. So I think that the previous speaker kind of gave the whole show away because her reference is always to the masculine and never to a woman potential president or vice president. It's never reference to a woman being a perpetrator of a sexual offense. And I find myself also thinking as I listened to her, I couldn't help but think of Bill Clinton and the allegations made against Bill Clinton.
100%.
And then I'm also kind of baffled by all of the proposed amendments that we've seen, because the way I read the bill, and maybe I'm just reading it all wrong, is I wonder, in the federal court, do you have to get an information? Have an indictment? Have some kind of long-form charging instrument instead? Do you then have a preliminary hearing in some cases if you're not having an indictment? In other words, do you present to a judge? Do you not have a prosecutor who's going to present to a judge? Do you not then have the same burden of proof and the same standards of proof in the federal courts? I mean, it's the Democrats who've been telling us how wonderful the federal courts are for for ages. And I find myself just kind of baffled by the whole thing, like you just don't trust the federal courts that you've been lauding all this time. I'm kind of baffled by that. I'm kind of confused by that. But in reality, if you read the bill, which I just read it again because I thought maybe I'm just absolutely, totally baffled by this thing. You still have the same burdens of proof, same due process issues that you're going to have at the state courts. So it seems to me that really what you want to do is undermine the very purpose of the bill and continue to allow vitriolic, specious, without substance state prosecutions, which then actually does what we exactly saw against President Trump, and that's forum shopping at the state level. That's what you saw. That's what happened. And so with respect, I'm trying to understand the gentlelady's amendment, but as I review this, it looks to me and seems to me that this amendment is part and parcel of all the other amendments that are really actually trying to create some kind of political statement as opposed to actually solving issues. And that's kind of like what I saw on the floor of the House last night. I mean, I love the little popsicle sticks with the little construction paper signs. Those are pretty special.
Trying to spend less money.
And yeah, save on money. I appreciate you didn't want to be extravagant. And then I was grateful for the people. I was so grateful for the people who had their T-shirt on with their protest on it. They took off their outside coat. But what was I most appreciative about that, when they turned, they were actually facing me because I was sitting there, but I was about 6, 7 rows behind them. When they left the floor, I was grateful because I was able to move up and get a better seat. And I really appreciate that. May be the only thing I think that we're seeing moving together, working together on. That's a crying shame, but I was grateful to do that. The more serious and egregious one, of course, was waving one's cane in kind of a wild manner at the president. But the reality is, when I'm looking at the results of polling of people who actually watched the speech last night, it kind of gets at this whole thing that we've got here. And that is this absolute disconnect and failure to understand why the American people rejected you and your policies in such rich abundance at the last election. And that I think I'm going to draw a response here, but that's really what we saw on display last night. Sophomoric, childish, not even sophomoric, more juvenile than that, attempts to disrupt the joint speech. And I'll yield back. Or I'm waiting for the...
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you kindly, Mr. Chairman. Let me start with the digression to address my friend from Arizona. First of all, I'm delighted that we were able to show you what a nonviolent protest looks like, and I appreciate the fact that you praised people for bringing signs and popsicle sticks rather than steel pipes and Confederate battle flags and Trump flags to beat people up. And so that is indeed in the spirit of the First Amendment. I'm taken with your suggestion that this was a demonstration of why the people rejected us in such overwhelming numbers, and I keep hearing discussion of a mandate that's quite a mandate that's less than 50% of the vote and is the lowest popular vote victory in many decades. But in any event, congratulations to Mr. Trump for winning by a bit over 2 million votes. Joe Biden beat him by more than 7 million votes, and not only did you not accept the reality of that mandate, you didn't even accept the reality of his election. So that's the difference between the two parties here. We're willing to stand by the constitutional process, even when it doesn't go our way, which is what makes us constitutional patriots, I believe, that we don't say that we believe in the Constitution only when it goes in our own direction. Now, I want to rise in very strong support of the gentlelady from Vermont's amendment, and I want to salute her for introducing this amendment, which I do think everybody on the committee should support. Look, here's what the law is today. The president, the vice president can remove state criminal prosecution from state court to federal court if there is a valid constitutional federal defense. If there's a federal defense, then you get out of state court and you go to federal court. That's not enough for some of our friends because they want it to be a categorical removal. So we're going to just nullify federalism. We're going to nullify the jurisdiction of the state courts and say you can get out automatically. When? Well, you can get out if the act took place while you were in office, not that it was an official act, not that it was in the core functions of your office. It can be a private act, it can be a personal act, but you just have to have been in office, then you can remove to federal court. And then you can get the entire thing dismissed unless you can prove that it would not interfere with or impede or impair in any way your performance of your office. Like, tell me that that is not conferring immunity from criminal prosecution. So the gentlelady from Vermont comes forward and says, look, can we all agree that at least when it comes to rape and sexual assault, that's got nothing to do with the execution of your official duties? That's not what presidents and vice presidents are supposed to do? I mean, this reminds me of, I once took a class on European history, and we learned about the droit du seigneur, which was the right of feudal lords and monarchs to have sex with any woman that they wanted. They could simply decide that, that woman's for me on this night, even on their wedding night. The ruling was that you could exercise the droit du seigneur. Well, this says a president and vice president can basically engage in sexual assault. As we know, some presidents have engaged in adjudicated civil sexual abuse and been found guilty of it. They can do that as a president, as a former president, and then they can remove a state criminal prosecution to federal court, and they can get out of federal court by saying this is going to trouble them in their very busy lives. I mean, come on. This is a statement of second-class citizenship for women. And the gentlelady says, all right, you guys want to be able to, say financial fraud is something that you should be able to get dismissed as a president or a former president, as a vice president or a former vice president. But she says, at least for raping and sexually assaulting women, or in answer to the good gentleman, yes, a man could be raped or sexually assaulted too. Anybody. I understand the gentlelady's amendment applies in either direction, so we don't need to be detained with that particular distraction. But the point is that if a woman is going to be raped or sexually assaulted, the state should have the power to prosecute, regardless of who the defendant is. Yes, even the President of the United States, because just because you're big and powerful and rich doesn't mean you can go and grab them wherever you want. I yield back.
Gentleman yields back. Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. I classify this and file this under politics. And let me just say the things that sometimes people don't want to say. First of all, nobody wants a president or a vice president to engage in sexual assault. Let's all agree upon that. We realize that. We think it's wrong, whether it's a Democrat, whether it's a Republican. God help us, hopefully it doesn't happen. We all agree. But the question here is, again, let's talk about what's really happened in some locations. In some locales, we have state prosecutors. We have political prosecutors, political attorney generals, political DAs, a political legal system that can be and has been misused. And quite frankly, locally, when I say locally, I mean state, and even city or municipality, it can be misused more easily than it can be at the federal level. And it was misused last time, and I don't have time right now, but my good friend on the other side, Mr. Goldman, I'd be willing to show him for hours how, the system, the Department of Justice, and the judiciary at various locales was misused for politics. It was weaponized, and it was politicized.
Will the gentleman yield?
Not yet, I will though. And the point here is that, so we're taking an issue, and this is, again, this is stuff maybe nobody wants to say. It's a hard thing to vote against an amendment like that because nobody wants to be seen, and we are not, anti-woman or pro-sexual assault. I mean, come on. Nobody's for that. Nobody wants that to happen. but that this could be misused. Particularly, we see the kinds of prosecutors and DAs that we had at that local level. And we see, yes, President Trump was an example. And again, I'm going to use the same message, give it to you what I gave to you before. What goes around comes around. That's an old New Jersey saying. I probably have in some other places too. Goes around, comes around, man. Be careful what you wish for is another one, because it could happen in reverse. Because there are some places, and I would hope as a Republican that it never would happen in a Republican jurisdiction, but where you have a strong Republican system and a strong Republican attorney general locally. And I would hope that would never happen. I don't believe it would. But the point was, why would we open ourselves up to that? And I'm not an attorney, but I've been around them for a lot of years in my state level as a state senator and over the years in politics. Is there something wrong with the federal court system? We're acting like the federal court system is useless, worthless, that they can't deal with the issue. I find otherwise. All that we want is an objective, decent, honest way of dealing with these issues that are as non-political as can be. And the bottom line, I'll wrap up with this and I will yield, is that in these days, quite frankly, some of these cities and some of these towns are more political than they've ever been in American history. Ever. And we're misusing the system. And this is a way, it's a good bill to try to clean it up. I support women. Nobody wants a woman to be assaulted, for God's sake, or a man for that matter. It could happen either way, especially with the days of now transgender issues. You could have somebody that was a man that's now a very, very strong woman, I guess.
Okay, will the gentleman yield for?
I will yield, yes.
Thank you kindly, because I know of your feminist credentials, and I know you oppose sexual abuse even when the president is involved. The New York case was one in which a civil jury unanimously found that at that point the former president had engaged in sexual abuse of a woman in a department store. Afterwards, he denied it, and he said that it was a lie, it was all made up. She sued him for defamation, and she won again an $85 million verdict against him. So what part of that judicial process are you questioning?
You're yielding back?
Yeah.
So I will reclaim my time. I won't even go into that particular process. The part that bothers me in general, philosophically, we're not just dealing with one case and one president here. What we're doing is larger and bigger and more important than that. How are we dealing with the issue in its entirety and how it can affect anybody in any situation? So that's the issue here.
But your bill applies to civil and criminal.
And let me say this. There is no question, I'm sorry, I'm just going to say it, and I know you don't agree with me. Respectfully, I respect you. But, there's no question when you look at the prosecutors and the attorneys general in some of these locations, they ran on saying, they ran for office, to the public said, vote for me, I am going to find a way to prosecute Donald Trump. And it could easily happen the reverse way. Nobody should run for office and say, vote for me, I'm going to prosecute a Democrat president. It's wrong. I yield back.
Gentleman yields back. The gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman. So everybody's talking here about who the president is, who the vice president is, politics. I want to talk about this amendment and my support for it because of who the victim is. If you're a victim of sexual assault or rape, it is a pretty traumatic situation to even press forward with that case, to even get the evidence. I've done bipartisan work getting more sexual assault nurse examiners so that we can have somebody who has the ability to communicate with a victim of rape or sexual assault at the worst possible time and collect that evidence. If you're telling that victim now, you can't have your case heard in your community, you're going to have to go to the federal district court. Well, in some places in this country, that federal district courthouse is hundreds of miles away. It's not in an area where that person feels comfortable. it can be an intimidation factor for that victim. It is hard enough. And imagine if the perpetrator is the president or the vice president. That in itself is a chilling situation. So we are now putting yet another block to victims of sexual assault. And I don't care what gender the perpetrator is. I don't care what political party the perpetrator is. We need to think about the effects of what we do in this committee on the victim. And it is hard enough. I have dealt with victims of sexual assault. It is hard enough for them to come forward. And now you're asking them to go somewhere outside of their community in a situation where the U.S. attorney was appointed by the President of the United States, not looking to be helpful here. That is simply unacceptable.
Will the gentlelady
This is a common sense amendment. Yes, I will yield
But
to the
if you
ranking
just
member.
yield for a question, because I think if anything, your trenchant remarks are way too charitable towards what this bill would do, because you forget the dismissal provision. Yes, the removal provision is a nightmare because the victim would have to travel hundreds of miles to go and to testify in court in the hostile terrain of a federal court where the U.S. attorney may have been appointed by the president himself. But the dismissal provision means that it's extremely unlikely that the case would ever even go to court, because it says that it would have to be proven that this would not interfere or impede with the president or the vice president's work in any way. And you're one of the best lawyers I know. Can you imagine any circumstance in which a competent lawyer would not be able to show that this would interfere with the work of the president or vice president? Because it's not just they're removing it, they're adding a new weapon in the arsenal of the president, because all they have to do is say, this is going to interfere with my work, and now you've got to show it won't.
Absolutely. And, clearly this body has not thought it would interfere with an impeachment if something had to do with sexual assault. And so why, in God's name, would we create a situation where basically the victim is left with no recourse? It is wrong, and it is irresponsible, and it disrespects victims of sexual assault and rape. And I yield back.
Gentlelady yields back. Gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. And I do support this amendment that would prevent removal of cases involving sexual assault, battery, or misconduct. But I wanted to point out something that we discussed in the hearing yesterday about this bill, which is Section 1456D. I think this amendment and the discussion about whether or not sexual assault, et cetera, are within the scope of duties of the president points out one of the underlying fatal flaws of this bill. So that section, 1456D, provides that no court can define or limit the scope of the duties of the president. So that means if a president were to argue that sexual assault is within the scope of duties, no court could say, no, it's not. Similarly, we saw with respect to the civil suit in New York that's been discussed, the president tried to argue that his defaming the victim in that case was somehow part of his official duties that would prevent a court from making that determination. So I think our experts here yesterday recognized the fact that this raises serious separation of powers concerns. If a court cannot determine what the duties of the president are, can a president ever be held accountable for anything? So I do support this amendment, but I think what it does do is point out a really important, and as I said, fatal flaw in the legislation that's being moved today. So I'd yield back.
Gentlelady yields back. The question occurs on the amendment from the gentlelady from Vermont. All those in favor say aye.
Aye.
Those opposed, no. No.
I ask for a recorded vote, Mr. Chair.
Opinion of the chairs, the noes have it. The gentlelady asks for a recorded vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Klein? Mr. Klein votes no. Mr. Knott? Mr. Knott votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 10 noes.
The amendment is not agreed to. I think we're ready for. Without objection, the amendment. Question on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit
Can we have a
views.
recorded vote, Mr. Chairman?
Gentleman from Maryland asked, the ranking member asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Massey votes yes. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Vandrew? Mr. Vandrew votes yes. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes yes. Mr. Harris? Mr. Harris votes yes. Mr. Onder? Mr. Onder votes yes. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin?
Nope.
Mr. Raskin votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes no. Mr. Goldman? Mr. Goldman votes no. Ms. Crockett? Mr. McClintock? Mr. McClintock votes aye.
Mr. Issa?
Mr. Issa votes aye. Mr. Fry, you are not recorded. Mr. Fry votes aye.
Gentleman from Wisconsin?
Mr. Grothman votes yes.
How many? Two. Gentleman from Alabama?
Mr. Moore votes yes.
Mr. Chair, I would like to impose and invoke Rule 86?
Gentleman is stating a rule. I'm not sure what he's talking about.
Rule 86 says if there's a vote during lunch, that it has to be announced
Is that a Tennessee rule?
12:35.
Is the ranking member not providing the minority party lunch?
If the gentleman from Tennessee would like to come, we have burritos for you.
We don't have the budget for it.
Well, no, we take care of our own. So there's lunch back there for the Democrats. And you're welcome to join us, too. I think we may have more appetizing fare over on our side. I don't know.
I certainly wish you had told me, before my bill was coming up. Although we could see those and then come back to this bill. The judges. The gentleman from Tennessee perhaps noticed that there were no judges being added in Tennessee. Is that the nature of his amendment?
They might just have to remove it to state court.
Mr. Hunt? Mr. Hunt votes yes. Ms. Lee, you're not recorded. Ms. Lee votes yes.
Ms. Crockett's on her way in.
Gentlelady from Texas, recognized.
Ms. Crockett, you're not recorded. Ms. Crockett is a no.
Clerk will report.
Mr. Chairman, there are 14 ayes and 11 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 1526, the No Rogue Rulings Act, for purpose. Oh, that's right. We're going to do the other order. Okay. Pursuant to notice, I now call up the Judges Act of 2025 for purpose of markup and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 1702.
Without objection, the bill be considered as read and open for amendment at any point. That has multiple meanings, doesn't it? Chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. Okay, there, we'll go back. Thank you, Mr. Chairman. Last week, we held a hearing on the crisis that undermines the federal courts. That hearing reiterated the staggering caseload and backlog that delay justice and deny Americans swift resolutions of their pressing legal matters. Following this hearing, I introduced H.R. 1702, the Judges Act of 2025. And I reiterate, the Judges Act of 2025. The reason that's an interesting name is because the Judges Act of 2023 was substantially similar, along with Representative Kiley, Lee, and Nellis. The text of this bill is nearly identical to Senate Bill 4199, which passed the Senate unanimously in August of last year and passed on a bipartisan basis out of the House of Representatives in December after the election. Unfortunately, during the waning hours of the last administration, the President vetoed Senate Bill 4199, and in my opinion, falsely stated, and I quote, "unnecessary for effective administration of justice," end quote. Nothing could be more misguided than that statement. This is in opposition to Senate Majority Leader Chuck Schumer's unequivocal support for the bill, saying, quote, "It is bipartisan, it is prudent, it is responsible," end quote. Mr. Chairman, the bill is not a Democratic vote. It is not a Republican vote. It is not even a Democrat or Republican bill. It is, in fact, necessary for the effective administration of justice. The bill takes critical steps to strengthen our federal judiciary and restore the ability to serve the people effectively. The Judges Act of 2025 enacts the recommendations of the Judicial Conference, creating 66 new district court judges in our most overburdened districts. It is a balance of forward-looking spending, sending needed judges across 6 phases between 2025 and 2035. The judges will be spread across 3 different presidential terms and 6 different congressional Congresses, ensuring fairness and impartiality to the greatest extent possible. These positions are distributed equitably among red and blue states, avoiding any partisan advantage and focusing solely on judiciary's current pressing needs. The bill also addresses challenges unique to specific jurisdictions. In fact, it improves accessibility to the federal court in large judicial districts by authorizing new courthouse locations in Texas and California. And good governance is at the heart of the Judges Act. The bill requires the Judicial Conference to make its judgeship recommendations publicly available, including methodology and survey results used to determine the needs for new seats. Also, the bill requires the Government Accountability Office to evaluate the efficiency of federal appellate and district court activities, as well as federal agencies' need for detention space. With a discretionary cost of less than 5% of the federal judiciary annual budget, this legislation is prudent and essential in the investment in a judicial system. I'd like to take a moment to address my friends on the Democratic side of the aisle, many of whom co-sponsored the bill in the last Congress, but who now may oppose now that President Trump won the election. Democrats and Republicans agreed in the last Congress that this bill was important and needlessly, regardless of whether Trump or Harris won the election. Again, I'm going to reiterate, we all agreed in voting for the bill that either President Trump or Vice President Harris was going to be the next president of the United States. And yet, all of the Senate and a majority of the House, including 29 Democrats, knowing that in fact one or the other was going to be president, and in the case of the House, knowing that President Trump would be next, voted for the bill. That is why we supported the bill even without knowing who would be the president when we wrote it. And I hope my Democratic friends will put country over party again and help pass this critical legislation. I'd urge my colleagues to consider this. And we'll be passing out a flyer that shows the details. In every case, it just happens that these judgeships are in either all blue states or all red states. And I think this is important. With 37 blue states, meaning 2 senators who are Democrats, and only 28 Republican states in which both senators are Republican. With the blue slip and at district court, it means that in 37 of these judges, including the majority for the Trump administration remaining 4 years, the majority will be controlled by senators who can withhold until they get an acceptable candidate, meaning they will not have MAGA Republicans. They will have Republican-leaning or moderate-leaning judges who are acceptable to 2 Senate Democrats in addition to the President of the United States. And I think this ensures that the court will remain balanced during that period. Additionally, I would note that the Senate is currently in Republican majority, but that has switched back and forth so often that there's no telling in the second 2 years of the Trump administration who will be in charge of the Senate. So for that reason and more, I ask the members to look at the bill as open-mindedly as we did in the previous Congress, vote for it accordingly for the best interest of the American people. And with that, I yield back.
Gentleman yields back. The ranking member is recognized for an opening statement.
Thank you, Mr. Chairman, and thanks to Mr. Issa for that lucid description of where we are. I do think it misses one critical point. In the last Congress, we reached a bipartisan, bicameral deal. 66 new federal judgeships spread out over 10 years, over 2.5 presidential terms, starting with the next unknown president of the United States. This is the Rawlsian original position. We all can agree to it because it might favor the Democrats, it might favor the Republicans. We would all agree. And last week, in this hearing room, I offered to go back to that exact deal at any time. This is the only way it's worked or it's ever worked or it's going to work now. We agree to expansion of the judiciary in the first year of the next presidential administration of an unknown president. It's been over 30 years since we added more district court judges to the bench. We all agreed that the courts need more judges. We used the recommendations from the Nonpartisan Judicial Conference to get the numbers, and crucially, we agreed that the appointment tranches would begin with the next unknown president. We're all jumping in together. The Senate held up their end of the bargain. They passed the bill by unanimous consent last August before the election. But House Republicans, who as the majority party controlled the schedule on the floor, the sending of bills to the floor, refused to move the bill until they knew that their party had won the presidency, despite the fact that Mr. Nadler, Mr. Johnson, all of us were urging them to move it before, and they refused to do it. They didn't just kill the deal that we made. Their maneuver doomed any hopes for a nonpartisan increase in federal judges. So why the sudden rush now to get more judges on the bench? Well, it's clear that with congressional Republicans on the sidelines, with Elon Musk essentially taking over all of the policy initiative, the judicial branch is the only branch of government providing an appropriate check on the lawlessness and the chaos of Trump's administration, which means the federal court system is the next target. They've got to get judges on the bench because I think we have now certainly over 30, but it may be 35 judges that have issued temporary restraining orders or preliminary injunctions against the massive trampling of the lawmaking powers of Congress under Article 1. There are courts that are standing up against the violation of the civil service rights of workers at the Consumer Financial Protection Bureau, the Department of Treasury, the Department of Education, the Agency for International Development. There are 5 different courts that have struck down Donald Trump's absolutely lawless executive order purporting to destroy birthright citizenship, which is provided for in the very first sentence of the 14th Amendment adopted in 1868. And so with the courts standing up for the Constitution and the Bill of Rights, with Congress being completely sidelined and bypassed by the administration, the push is now on to get these judges that our colleagues would not go along with providing for when it was under the veil of neutrality that we had adopted in the last session. So I'm sorry that we are where we are now. We will absolutely go back to that deal. That is the only amendment we're going to offer here, to go back to the original deal that Mr. Issa, Mr. Johnson, Mr. Nadler had struck before. And I thought that we were all going to stick to. We will do that again. We will pass it today. And we will pass it as an amendment to this bill, or we'll go ahead and we'll introduce that bill again. But this is the only way that it really works. And obviously, we're not going to be party to another court-packing scheme. Mr. Isis shows some statistics and makes the argument that the Democratic senators would be able to exercise a kind of brake on the judges to be nominated by Donald Trump. I think we talked about last time, well, that they wouldn't send forth real MAGA judges. It would be more like the corporate Republican variety of judges. In any event, that presupposes that the GOP on the Senate side won't simply get rid of the blue slip process as applied to district court nominations. That's what it did in 2017 with respect to federal appeals court nominations. They just got rid of the blue slip. And so I'm afraid that Mr. Ice is making an offer that he can't follow through on, because the Senate Republicans may decide to do away with the whole blue slip process, in which case we've just knowingly created judges for Donald Trump to pack with more people like Eileen Cannon. And we were willing to take that chance before the election. Our colleagues were not willing to gamble on the results of the election. And so now we say, let's go back to the original deal. I yield back to you, Mr. Chairman.
The gentleman yields back. I would just point out the gentleman used the term court packing scheme. I would just, again, underscore what the sponsor of the legislation said. The Judicial Conference is for this. This passed in a bipartisan way in the Senate, unanimously, passed in a bipartisan way in the House. Unfortunately, President Biden wasn't willing to sign it. If we want to talk about a court packing scheme, it's the bill that the former ranking member of the committee sponsored in the last couple Congresses, I believe. I don't know if the current ranking member was part of that, but that was the bill to add 4 associate justices to the United States Supreme Court. That is court packing. This is a bill that is the Judicial Conference wants. Mr. Ice has put together with bipartisan support, and it simply, I think, is just good common sense that we pass it and help the overburdened judicial branch of our government. With that, I recognize the gentleman from California offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature.
Without objection, the amendment in the nature of substitute will be considered as read and shall be considered as base text for the purpose of the amendment. The chair recognizes the gentleman from California explain the amendment.
Thank you, Mr. Chairman. This bill is changed only in a very small and technical way. The amendment modifies the title of the bill so when everyone understands it is 2025. It does adopt the Senate 12-year or the longer term. It's sort of three full Congresses, and it takes out a provision no longer mooted because of another piece of legislation that passed. With that exception, it is the Senate bill as it came to us, and that is what we intend to do. And I yield back.
Gentleman yields back. Who seeks recognition? The gentleman. Do you want to go? You were. Gentleman from Tennessee.
Thank you, Mr. Chair. Yesterday, I was surprised to learn that the richest, smartest, most magnificent, brilliant person in the world, Elon Musk, had proposed closing 400 federal buildings, one of which is the federal courthouse in Memphis, without a new courthouse. All of a sudden, we're going to put it up for sale or get rid of leases. The Odell Horton Federal Building is a building that has my office in it, as well as it has my 3 predecessors' offices was in it. Senator Hagerty's office is in it. The U.S. attorneys are in it. The federal judges are in it. And the U.S. Marshals in it. How can we be considering having new judges when we're dispossessing other judges and putting them out on the street? That's wrong, even if it's the most intelligent, richest, brilliant man in the world. The other federal district courthouse in Tennessee is in Jackson. It's a very small building. It won't hold the 9 judges that we have in the West Tennessee, so that won't work. There are other federal courthouses for sale here that will be for sale without having created new buildings. Mr. Issa mentioned that in Texas and I think maybe California, they were going to have new courthouses built. Well, you got to have a courthouse. You just can't come up here and just say we're going to sell the building. GSA hasn't given us an answer. GSA has said that they're going to look into it, and they've taken the list off their website. That doesn't help us a lot. It's a lengthy process to get a new courthouse. So before we start naming new judges, we probably ought to figure out where we can have courts sit and meet and have that action. And maybe we should just take this bill and hold it for a while until the greatest, most brilliant, smartest, most absolutely phenomenal judicial and real estate mind in the world, Elon Musk, can come and tell us what he's going to do with the judges.
Will the gentleman yield?
Please, yes, I will.
So thank you so much for pointing that out. I think Tennessee's not the only target for federal court closure here. I assume the answer might be, well, those federal judges rendered homeless by the closing the buildings could work from home, but of course that would violate the order that they're not allowed to work at home. They've got to get back to work, where they would be fired, presumably, by Elon Musk, or they would be given the offer to work to not work, but to get paid for the next 8 or 9 months under the fork in the road, which was another extraordinary offer developed by the most brilliant innovator in the world, that 2 million people should actually not work but get paid by the federal taxpayers in critical functions like air traffic controller, food and drug safety inspector, nuclear site guard, cancer researcher, and so on. So I don't know whether the gentleman would consider withdrawing the bill until we get some clarity as to whether or not there'd be any place to house all of these federal judges, but I'm happy to yield back.
Thank you, and you're right. I mean, he had those, and Mr. Brilliant, who said, well, we'll make a few mistakes, but we'll correct them immediately, and he mentioned Ebola. He didn't mention the mistakes that he'd made with knowing when Social Security took people who hadn't got their death certificates filed and gave them a date of birth in the 1870s, which obviously most of us knew because we read about that and saw what the problem was, but Mr. Trump and his speechmaker didn't see it because they read it off last night like these people were all getting money, which is absurd. And they also didn't have the bird flu, and they took people off of that and fired them. So yeah.
Would the gentleman yield?
Yes, sir.
You know, I'd like to speak in support of your point strongly. This committee authorizes specifically where judges can hold court. That is our jurisdiction. A colleague who came into Congress with me is now currently the chairman of the TNI, and they authorize the courts, the actual production, including the one that I need expanded in the coming years internally. So I think it's fair for the gentleman to say that announcements by anybody in the executive branch are just that, their intentions. The reality is this committee shall insist on its jurisdiction of the time, place, and manner of our courts, and working with TNI, we will make sure that the facilities are there. That is not an executive branch decision. It is discretionary to do what you may suggest could happen, which would be to find judges without courtrooms while we have judges. We will not allow that, and I would share with the gentleman the pushback if that were to happen.
Gentleman's time has expired. Ms. Lee.
Thank you, Mr. Chairman. The Judges Act is a vital piece of legislation that will address a critical shortage of Article III district court judges. As our population and our litigation continues to grow, as the caseloads continue to rise, we must equip our judiciary to be able to meet the needs of the public. This includes an appropriate and adequate number of judges to hear and resolve cases. The claims that we are hearing today that this bill is in any way partisan, or worse yet, the claim that it is in some way tantamount to court packing, are grounded in neither fact nor reality. In fact, this bill is specifically designed to stagger the creation of new judgeships so that they span multiple presidential administrations. Some of the vacancies occur now, and others will span future administrations so that there is no partisan certainty nor any sort of partisan manipulation associated with the creation of these new judicial spots. I come from the Middle District of Florida, which is the second most populous district in the country and has one of the heaviest caseloads anywhere in America, whether we measure by using weighted or unweighted caseloads. I have seen firsthand the diligence, the dedication, and the hard work of our judges and their staffs as they attempt to meet the need of the ever-increasing burden on our federal courts. The staggering workload and case filings have a very real effect on the judges who are trying to do their job effectively and on the citizens of our communities who are coming to the courts to have their disputes resolved. We heard testimony just last week about the significance of the increase in workload and how it is affecting both the judges and our communities. In Congress, it is critical that we respect and support the courts as a co-equal and independent branch of government. And a foundational part of doing that as members of Congress is to ensure that we do our job and properly staff and equip the courts. I encourage my colleagues to support this important piece of legislation. Mr. Chairman, I yield back.
Gentlelady yields back. Is there further discussion on the ANS? Mr. Goldman.
Thank you. Thank you, Mr. Chairman. I find it interesting to hear my friend from California talk about how we have jurisdiction over judges and whatever the executive branch says is just their intent and just advisory. I wish my colleagues on the other side of the aisle would view Congress's power of the purse in the same way. Because what my colleagues are doing is essentially rolling over and giving all of Congress's power of the purse, all of its oversight and accountability responsibility to Donald Trump, Elon Musk, and the administration. You all have no idea what Elon Musk is cutting. And we know that because Elon Musk has no idea what he's cutting. 10 of the 12 top line items in the so-called transparent wall of receipts were determined to be false, inaccurate, incorrect. And yet, you want to assert your jurisdiction over courthouses and where judges are, but you don't want to assert your own jurisdiction over where money is spent. And we are now coming up on a deadline to fund the government. And by all accounts, the proposal that we are expected to see is a continuation of the current budget and the spending that has been cut by Elon Musk. So you are proposing to support continuing funding of programs that are allegedly waste, fraud, and abuse. And what's more, by doing that, you are just giving the administration more and more authority and more power to make their own determinations about where money is spent. And it bewilders me why people would want to come to Congress, be away from their families, travel across the country, just to hand over all their authority to Donald Trump. And that's what has been going on. It very well may be that Elon Musk has found waste, fraud, and abuse. And we would love to work with you on identifying and eliminating waste, fraud, and abuse. We certainly do not support waste, fraud, and abuse and agree that our government bureaucracy has swelled and is too slow. But there's a process for that, which was used by past presidents. I hear my colleagues referencing that Bill Clinton and Al Gore cut 400,000 jobs. And that is true, but there was a process. They did a determination as to whether or not those jobs were needed. They then came back to Congress and made suggestions, and then Congress voted on it. There's a process for it, but you all are so afraid of Donald Trump and Elon Musk's money that you won't even ask them to tell us what they're doing. It's a complete abdication of your role, and yet we hear now that, oh, we have jurisdiction over the courts. The executive branch does not. I wish you would be consistent, because I agree with you, we do. And I wish you all would assert your own power in things that really are affecting the American people. And Elon Musk is now reportedly gearing up to fire 80,000 more veterans, cut the Social Security Administration in half, remove all the regional HUD offices. This is not Twitter. You can cut Twitter by 75% if you want, and what happens is you get a crappy social media platform. If you cut the federal government by 75%, you are cutting services and funding that are essential to hundreds of millions of American people. And so I hope, Mr. Issa, you will take that view. I know you are acting in good faith, and I hope you will apply it to the usurpation of power by the executive branch right now. And I yield back.
Gentleman's time has expired. Is there further discussion on the ANS? Mr. Knott.
Thank you, Mr. Chairman. I will follow Mr. Goldman and say that we had a delightful conversation last night about the experiences that we both had representing the United States in a previous life. And I was recounting to him on the floor of the House that for me personally, there was no greater honor than to stand in front of a jury and to say, I represent the United States. And we both lamented how, in some ways, partisanship has filtered down to local prosecutors' offices and local court systems. And it is because of that, and one of the reasons that I would support this proposal is because it is nonpartisan. This was the bill that was recommended by the Judicial Conference. There was support in the previous Congress for this bill. Without question, there is a great need for new federal judicial nominees and seats. And we as Congress, we owe it to our constituents, we owe it to the country to enable the court system to administer justice and to meet the needs of the population. And from my own district in the eastern part of North Carolina, there is clearly a great need. I was not here last year, but I will certainly put in a plug at some point to address those needs. But this bill as it currently stands, I'm in full support. And given that it was recommended in 2023 by the Judicial Conference, it staggers the nominations. I think it's a great recipe for a need that all of us feel who practiced in front of federal courts across this country. I yield back.
Would the gentleman yield?
Yes, I yield. Mr. President.
Okay, I'll be brief because I'm not going to probably seek time on my own. I'm going to just make one appeal that my colleagues consider before this comes to a vote. When this passes the House, it may or may not pass on a bipartisan basis as it did last Congress. But let us all understand, it is going to the other body. The other body took our language, made their own language, and passed something unanimously. The other body is the body that some members here doubt that they will retain what they have had for generations, which is the blue slip respected at the district court level, and these are all district court. I would say to my colleagues, talk to your senator, and I think what you're going to find is that your senators will say they're quite comfortable they're going to keep the blue slip or they won't vote for the bill. And this bill will not pass the Senate unless it gets 60 votes to get past cloture. So understand this will be a bipartisan bill in the Senate, perhaps in its current form, perhaps with some senatorial discretion. but it will pass on a broadly bipartisan basis. I would ask that we consider making it do just that here for the benefit of all. And I thank the gentleman for yielding.
Will the gentleman yield? Will the gentleman yield?
Gentleman, Mr. Knott, yield?
Will the
I yield.
Thank you. I just wanted to see if I could assist Mr. Goldman in some of his confusion over the fundamental architecture of our Constitution, which is, of course, the separation of powers. Congress makes law but cannot enforce it. The President enforces law but cannot make it. The Congress declares war but cannot wage it. The President wages war but cannot declare it. In the case of this bill, Congress creates positions but cannot fill them. The President fills positions but cannot create them. And regarding his confusion over Mr. Musk's role in this process, Congress appropriates funds but cannot spend them. The executive spends funds but cannot appropriate them. I yield.
Will the gentleman
back to
yield
Mr.
for a
Knott.
question?
To Mr. Knott.
I yield.
Thank you. Mr. Chairman, if I don't disagree with you, I guess the question I would have is,
Then my job here is done.
is there any oversight responsibility from Congress to ensure that the President and the executive branch follows the laws that we pass? Because I sat here for 2 years in the last Congress, and I can assure you that you and your colleagues have a very expansive view of Congress's oversight authority, at least when there's a Democratic president. But when our laws that are passed are blatantly disregarded and violated, somehow that oversight authority just goes away. And so I would point out to you that you are right, except that we do have an obligation to hold the executive branch accountable to abide by the letter of the laws that we pass. And I hope you will take that upon.
We cannot declare ourselves the executive branch of the government. The Constitution vests that authority with the President. Gentleman's time has expired. Is there further discussion on the ANS? Mr. Nadler.
Mr. Chairman, I have great respect for the gentleman from California, Mr. Issa, and I was proud to work with him and with Ranking Member Johnson in good faith during the last Congress to advance this legislation. We agreed on the need to authorize new federal judgeships for the growing caseload in the federal courts. But we also agreed that it was absolutely essential that we consider this legislation before the presidential election so that it could be voted on before anyone knew which party would control the first set of judicial appointments. The Senate held up its end of the bargain and passed the bill unanimously over the summer. But unfortunately, the Republican leadership decided to play politics. Despite our urgent pleas to move the bill to the floor before November so that neither party would have an advantage and both would be taking an equal risk, they decided to bottle it up. It was only after their candidate won that they brought the bill to the House floor, breaking the essential element of the deal. And when Democrats opposed the bill, Republicans had the audacity to cry foul and to say that we were playing politics. It was a sad demise for a bill that should have been a true bipartisan success story. I had hoped that after this episode, we would all take a moment and restart bipartisan negotiations on the path forward. But instead, we are barreling ahead, taking up the same bill with the same timeline for creating new judgeships, which presents exactly the same problem we faced in December. We have already seen what kind of judges Donald Trump puts on the bench. During his first term, he stacked the courts with dangerously unqualified and ideological appointees, many of whom appear to be more faithful to Donald Trump and his agenda than to the rule of law. And now, with a nearly unbroken losing streak in court to begin his second term, it would be irresponsible to give him 23 new appointments that he can use to install judges who are unwilling to stand up to his administration's unlawful actions. Mr. Chairman, no one denies that new federal judges are needed. The only question is how to add them in a way that is fair to all parties. I hope that we can return to the spirit of bipartisanship that first animated this bill. But if Republicans insist on jamming this legislation through on a partisan basis once more, I must urge my colleagues to oppose it. I yield back.
Gentleman yields back. Is there further discussion on the ANS? Mr. Mr. Moskowitz.
Thank you, appreciate it, Mr. Chairman. Former Chairman Issa said something that I found interesting. I wanted to see if he would engage on it, because I think maybe there's a moment in which we could work together. He said, and he's right, by the way, that Congress and this committee, along with T&I, have jurisdiction over those federal buildings, and not Elon Musk. Elon Musk and the executive do not have jurisdiction, and I don't want to put words in his mouth, but I believe that was the summary, that it's this committee. Would the gentleman ask the chairman of this committee to do a committee letter together, Democrats and Republicans, a committee letter to Elon, letting him know that we appreciate his recommendation, but we have the jurisdiction, along with transportation, over the federal court buildings and not the executive. If this committee would do a letter to Elon asserting that authority, I'll vote for the bill.
If the gentleman would yield?
I would.
I can't speak for the chairman of the full committee, but as chairman of the courts subcommittee, I'm happy to enter with my ranking member a letter. I will be with Elon Musk this evening, oddly enough, on other matters. And when I heard this from the gentleman from Tennessee, I planned on asking him a question about it. I'm happy to take a bipartisan letter saying, you know, it is the opinion of this committee that that courts currently housing judges, in concert with T&I and GSA, can only be closed or replaced to the extent that there are facilities sufficient for now and anticipated additional judges. You're absolutely right. It could be that the gentleman from Tennessee said may be true, or it may not be, but it's clear that this committee is not going to have judges unable to perform their job. Just the opposite. We sometimes push pretty hard on T&I to try to get our courtrooms up to snuff, because oddly enough, the federal court kind of pays for their own courtrooms, but GSA oversees it and T&I authorizes it.
Just reclaiming my time real quick. And so I appreciate that you're going to have a private conversation with Mr. Musk.
No, I said I would take a letter to him.
Yeah, so, I mean, the question I have then, and I appreciate your support. And so...
And I appreciate your vote on the bill.
Well, we're not there yet. We're not there yet. This is a work in progress, because I see the chairman hanging in the doorway. Will the Judiciary Committee, it can be a polite letter to Elon, it doesn't need to be antagonistic. Will the Judiciary Committee assert its authority and notify Elon Musk that it is this committee, along with T&I, that has jurisdiction over whether the courts close or not, and not the executive? Will we make a public statement, Democrats and Republicans, on official Judiciary Committee letterhead? Will the chairman commit to that? If the chairman will commit to that on the record, that we're going to do a letter together as a unit asserting our constitutional authority, I'll vote for your bill.
You mean I'm just chopped liver? Or the subcommittee chairman isn't good enough?
Listen, remember, as a Jew,
You had me at hello.
Listen, as a Jew, I love chopped liver, especially during Passover. So,
And as a Shabbos Goy, I'm telling you,
exactly.
you know, I'm not chopped liver. Come on.
Right.
So are you willing to take, you know, this is like Shark Tank. Are you willing to take a subcommittee chairman?
A great sub.
Give him all the minerals in South Florida. The mineral rights.
I'm not willing to part with the mineral rights of South Florida in exchange for this letter, okay? But I will cut off aid, if you know.
Will the gentleman yield?
I will yield.
Just to clarify the terms of your offer, you're talking about a public letter, right?
A public letter on judiciary stationery from the committee with Democrats and Republicans on it. Again, doesn't have to be antagonistic, but just letting him know that the executive branch does not have the authority to close those courts. That is vested in this committee and in T&I.
If the gentleman further yield.
I will yield.
I've been informed that we will work diligently to have that letter ready by the time it comes to the full House floor. So hold that vote.
Fair.
For the floor, if you would, please.
Fair enough.
I thank the gentleman.
I'll make that deal with you.
Thank you.
Gentleman yields back. Is there further discussion on the ANS? Gentleman from California is right.
My colleague from California just want to clarify, you will have that letter on the floor.
Now, what I said is I'm going to work with the chairman to see if we can have that letter. The gentleman had said he would vote for it if the letter goes out. we're going to clearly need some time.
So you going to make any commitment right now?
I'm making the commitment to work diligently on it. Are you making the commitment to vote for it on the floor if that letter goes out?
I'm making a commitment to vote for it right now if you will essentially work on that.
Well, if you'll take the subcommittee chairman, I'm willing to, like I say, I'm going to be
So the
with.
subcommittee chairman is on, and the full committee chairman is working on it as well.
That's correct.
Thank you.
Will the gentleman yield?
Of course.
That sounds like a pretty good deal if you're going to go with it. I mean, a public letter with you and the subcommittee chairman to Elon Musk saying that this is within the jurisdiction of our committee and within the jurisdiction of Congress and not up to him, that's a positive step. Yield back, thanks.
We said it was going to be a polite letter, so I'm not going to say it's not up to him. I'm going to say it is up to us. Because it is. We will assert our jurisdiction. Look, there is nothing more important to this committee than making sure that the people who adjudicate federal cases, including constitutional cases, have the assets necessary. And that has been an honor for me to serve on this subcommittee that way. And I do take it seriously, and I appreciate the gentleman's help and vote and signature on that letter.
It's your commitment to
I thank the gentleman.
moving forward with this issue. Thank you, sir.
Gentleman yields back. Is there further discussion on the ANS? Does Mr. Grothman seek time to yield to Mr. Knott? Gentleman's recognized.
Thank you, Mr. Chair. May I ask my colleague a quick question? Is your letter intended to preempt some action for court staffs, judicial staff? I guess, what's the impetus for the concern?
Is that to me?
Yes.
Sure. So I just, the point of the
Sorry if I'm being redundant.
No, you're not being redundant. And listen, I'm not gonna draft Mr. Issa or Mr. Jordan's letter for them. I think the point is Mr. Issa made a passionate plea about how this should be a bipartisan issue and made a bipartisan plea that this power is reserved within Congress, within the judiciary branch, within the Judiciary Committee, and within T&I, after the information that Mr. Cohen brought up. And so what I'm trying to do here is I'm trying to say, then as Democrats and Republicans, let, in a polite way, because I know we're not going to get impolite with Mr. Musk, we don't want to upset him, but in a polite way, do a letter just informing him that while he has his opinion and made that statement, that actually that power is reserved here. And I think together, as a unit, speaking together, I think that's important, because what you're asking us to do is to take a leap of faith. And what I'm asking you to do is to make sure the executive branch doesn't step on powers reserved for Congress.
Thank you.
Would the gentleman yield?
Yes.
Would the gentleman yield?
Yes, I yield.
Thank you. Firstly, I'd like to make you see on the list of properties that they were talking about.
Without objection.
And secondly, I would like to commit to Mr. Issa to vote for the bill on your kind offer to stand up for this committee. So I'm on the bill.
Gentleman yields back.
I yield.
Mr. Grothman yields back. Is there further discussion on the ANS? Yes. Oh, you've already spoken.
It's an amendment.
Oh, Chair recognizes Mr. Raskin for an amendment.
And I've got an amendment at the desk, Mr. Chairman.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1702, offered by Mr. Raskin. Page 2, line 14, strike 2025 and insert 2029. Page 5, beginning line 2.
Without objection, the amendment will be considered as read. Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And I, too, pledge to vote for the bill if we pass this amendment. The amendment is simple. It reinstates the agreement that Republicans and Democrats unanimously agreed to last year. Mr. Issa's bill touches on an area where there is actual substantive agreement between the two parties. We agree the courts need more federal judges. It's been more than 3 decades since we passed a law increasing their numbers. And for a few months last Congress, we all had a unified plan to do something about it, a bipartisan deal to give the federal courts all of the added judges that have been asked for by the Judicial Conference. Ranking Member Hank Johnson and Chairman Darrell Issa worked on a painstaking and honorable bipartisan basis to create a bill that would have spread additional district court judgeship appointments recommended by the Judicial Conference over multiple presidential administrations, beginning with the next unknown president. That was the key. Pass the bill before the election so no one would know whether this party or that party might benefit. The Senate upheld their end of the bargain and passed the bill on a bipartisan basis last August. Then, suddenly, mysteriously, incomprehensibly, the House GOP leadership suddenly broke the promise and refused to bring the bill up for a vote before the presidential election, before any of us knew who would be winning. Instead, they waited to know who would be the president. If it was Harris, obviously they would oppose it. If it were Trump, they would support it. So they broke the deal, and then they undermined the prospect of our actually dealing with this problem. I'd like to take a moment today to give my colleagues across the aisle now the chance for us to renew the original bargain and do the right thing. My amendment would simply reinstate the deal that we agreed upon last year. The number of judicial appointments is the same, the order of appointments by state is the same, and just as before, these appointments would begin with the next president, whomever that may be, of whichever party. You can join me and Ranking Member Johnson today in supporting the federal judiciary without any partisan politics. Let us have as our motto, equal justice under law, and not have as our motto, heads I win, tails you lose. I yield back, and thank you, Mr. Chairman.
Gentleman goes back. Is there further discussion on the amendment by Mr. Raskin? Mr. Issa.
I'll be brief. One, we can't wait 4 years. Justice delayed is justice denied. We have 3+ years of waiting on important cases, ones that cost the American people through both plaintiffs and defendants billions of dollars. We talked about the cost. The fact is the cost to the judges pales in comparison to the cost to the economy. Secondly, as I said earlier, we all supported this bill knowing full well that one of two were going to win, and we knew the names of the Republican and Democratic nominees. I'm not going to dispute the ranking member and others saying that it would have been better had we done it sooner. It would have been better had we done it in August. I'm not going to disagree with any of that. But we are where we are. I was always for it on a nonpartisan basis, strive to do so. The Senate, in an effort to be even better at it, in fact, stretched the term out a little longer. I will say to my colleagues, sadly opposing waiting 4 years, but I would strongly suggest that in concert with our friends on the Democratic side, including Senator Grassley, who previously affirmed that district courts would continue to have the blue slip, I believe that we can have a solid understanding that that will be maintained. Additionally, I'm happy to work with, because in our hearing, the judge and others affirmed that if we give judges anywhere, if they have to, they will move them around. I'm perfectly willing to look at the table that I handed out, work in good faith with both senators and House members to move around which states get it when, to try to find one that everyone agrees optimizes the nonpartisan nature. Some may say that moving forward red states actually would be better, since the blue states would possibly get a better deal under the next president, or vice versa, moving blue states so that using the blue slip, they can clearly limit the nature of those. I am Switzerland when it comes to that, other than perhaps having a certain feeling that Oklahoma needs them sooner because of cases that are pending there. But I'll work in good faith with anyone on those kinds of changes. I cannot move a bill in this Congress that delays for 4 years. The next Congress, we may be back here again talking about it, and as we get closer and closer to the end of the Trump term, we could do that. But if we wait those 4 years, we're not doing our constitutional duty. We're not doing what's right for the court. And I would ask that we move the bill today, continue working on it on a truly nonpartisan basis to find a final bill. And with that, I would yield back.
Gentleman goes back. Is there further discussion on the amendment by Mr. Raskin? Mr. Nails.
Yes, thank you, Mr. Chairman. I'm a proud co-sponsor of the legislation. I want to thank Representative Issa for championing this issue. It's a shame Biden You know, he vetoed this bill last Congress because it is a critical piece of legislation. The federal district courts are severely backed up across this country, and Texas in particularly bad shape. As of June 2024, the Southern District of Texas, which encompasses my district, had 6,082 civil cases pending and 8,928 criminal cases. And that is a massive backlog, folks. Districts like mine also have a lack of rural courtroom locations, which compounds the problem. The Judges Act would help alleviate this backlog by adding an additional 4 judges to the Southern District of Texas over the next 10 years, as well as an additional courtroom located right there in College Station, Texas. I urge my colleagues to support this legislation to ensure that our citizens have meaningful access to the courts, which is a fundamental right under the Constitution. I yield back.
Gentleman yields back. Is there further discussion on the amendment? Seeing none, the question is on the adoption of the amendment by Mr. Raskin.
Could we have a recorded vote, please, Mr. Chairman?
We call the roll first.
Oh, I thought you did.
Those in favor say aye. Those opposed say no. The noes have it, and the ranking member asks for a recorded vote. The secretary will call the roll.
Mr. Jordan. Mr. Issa. Mr. Issa votes no. Mr. Biggs. Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Fitzgerald. Mr. Klein. Mr. Gooden. Mr. Gooden votes no. Mr. Van Drew. Mr. Nels. Mr. Nels votes no. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Ms. Hageman votes no. Ms. Lee. Ms. Lee votes no. Mr. Hunt. Mr. Fry. Mr. Grothman. Mr. Grothman votes no. Mr. Knott. Mr. Harris. Mr. Harris votes no. Mr. Onder. Mr. Onder votes no. Mr. Schmidt. Mr. Schmidt votes no. Mr. Gill. Mr. Baumgartner. Mr. Baumgartner votes no. Mr. Raskin. Mr. Raskin votes aye. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Swalwell. Mr. Swalwell votes aye. Mr. Liu. Ms. Jayapal. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. Ross. Ms. Ballant. Ms. Ballant votes aye. Mr. Garcia. Ms. Kamlager-Dove. Ms. Kamlager-Dove votes aye. Mr. Moskowitz. Mr. Moskowitz votes aye. Mr. Goldman. Mr. Goldman votes aye. Ms. Crockett. Mr. Knott. Mr. Knott votes no. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Fry. Mr. Fry votes no. Mr. Garcia votes no. Mr. Garcia votes yes. Mr. Liu, you are not recorded. Mr. Liu votes aye.
Clerk will report.
Mr. Chairman, there are 12 ayes and 16 noes.
Vote being 12 in the affirmative and 16 in the negative, the amendment is not adopted. The question is on the adoption of the ANS. Is there further discussion? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor of the ANS will say aye. Aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no. Those opposed say no.
No.
The ayes have it. The bill is ordered to be reported favorably to the House.
Could we have a recorded vote, please?
Gentleman has asked for a recorded vote. The clerk will call the roll.
Mr. Jordan? Mr. Issa? Mr. Issa votes aye. Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes yes. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Baumgartner votes aye. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Mr. Nadler?
Mr. Nadler?
Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Ms. Jayapal? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes no. Ms. Crockett? Mr. Moskowitz, you are not recorded. Mr. Moskowitz votes no. Ms. Crockett, you are not recorded. No. Ms. Crockett votes no. Mr. Klein votes aye.
Clerk will report.
Mr. Chairman, there are 16 ayes and 11 noes.
Vote being 16 in the affirmative and 11, did you say, in the negative? The bill is ordered to report favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 1526, the No Rogue Rulings Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1526 to amend Title 28, United
Without
States.
objection, the bill will be considered as read and open for amendment at any point. Chair recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. Since the start of President Trump's second term, Democrat activists, with the support of sympathetic judges, have secured nationwide injunctions that have halted the implementation of more than a dozen executive actions and executive orders. The president's actions span critical policy areas that he was elected to address, including immigration, federal spending, regulatory reforms, and the like. Let me be clear, the injunctions are nothing more than partisan judicial overreach and have disrupted the president's ability to carry out his lawful constitutional duty. These nationwide injunctions have been exceptionally broad in scope and apply not only to the parties that sought the injunction in the case, but also to non-parties. meaning unlike class action suits, these are being classed without the creation of a class. This has allowed activist judges to shape national policy across the entire country, sometimes the Constitution never, in something this Constitution never contemplated. No Rogue Rulings Act, or NORA, curbs these overreach by district judges by limiting the scope of the injunctive relief to only those parties before the court, rather than being applied universally. Apply universally being, in the ordinary course of the Constitution, a right of the Supreme Court. By limiting the scope of such injunctions to just parties in a particular case, the bill will prevent any one of nearly 700 judges from making a decision that affects the entire country. The bill will also deter forum shopping because a president's political opponents won't be able to cherry pick a sympathetic judge who is most likely to go along with blocking the president from nationwide. This change ensures that legal challenges to the executive branch focus on the effect of the actions have on that party in a particular case rather than nationwide political ramifications. Let me be clear. If many parties join in a single action, many parties are present, but certainly not those not present, including throughout the country where they might, in fact, not want such an injunction. In short, NORA restores proper judicial restraint to focus on the effectiveness of the executive actions and actual litigations, and not political preferences by individual judges or interest groups. I want to make one thing clear. These cases behind me and our bill, if the shoe was on the other foot by the time we get done today, I want this to be a piece of legislation that is equally liked or disliked and equally fair, no matter who the next president is. We are not passing a law for the current occupant of the White House. We are passing a law that will improve the effectiveness of the executive branch and the reasonable challenges to actions by an executive branch now and for the rest of the many years of our great republic. I want to thank the chairman for bringing this important legislation to the committee, and I urge support for the bill, and I yield back.
Chairman yields back. I now recognize the ranking member, Mr. Raskin, for his opening.
Mr. Chairman, thank you very much. The chart is fascinating because the gentleman seems to imply, if you keep it up, that would be great, because the implication of this chart is that somehow the courts have done something wrong rather than Donald Trump having done something wrong. The reason there are 64 injunctions against him is because he is trampling the lawmaking and spending powers of the Congress of the United States. He's violating the civil service rights of federal workers, and he's betraying the federal law in every particular way. If anything, that chart demonstrates precisely why we need the law to be exactly as it is. The whole purpose of temporary restraining orders and preliminary injunctions is to stop actions by government that are causing irreparable harm, where there is a likelihood of the plaintiff to succeed on the merits of the case. And so the neutral law that my good friend from California is hoping for actually exists right now. This is the way it's always been. And so I don't know how many injunctions there were under Biden. I can't see. Is it 14? Well, I don't know. I don't know exactly what the right number is, but if there were regulations or actions by the government under Biden that met the standards of a temporary restraining order or preliminary injunction, then that is the necessary and proper mechanism of the law. But nobody's seen anything like what Donald Trump has been doing. As Donald Trump told us last night, you might love it, you might hate it, but as he said, it's radically unprecedented for the executive branch of government to go in to try to hollow out the federal government of the United States. So look, from our perspective, when Donald Trump says we're going to freeze all spending that has been appropriated by the Congress of the United States of America, that is a violation of our spending power, right? An Appropriations Act is a federal law, just like the law that says you can't beat up federal officers. An Appropriations Act is a federal law. It's not a budgetary recommendation to the president, and it might be right, it might be wrong, it might be the smartest appropriation in the world, it might be the dumbest appropriation in the world, but it is the appropriation of the Congress of the United States. And so the courts rightfully were saying, no, you have no power just to randomly, arbitrarily, unilaterally, monarchically freeze the spending of the Congress of the United States. We are the lawmaking power. So the gentleman's bill invites us basically to destroy a mechanism which is available to all Americans, and which, by the way, they freely availed themselves of under President Biden. There's a judge in Texas who became famous, although I can't remember his name. Somebody will tell me. Kaczmarek. Judge Kaczmarek, who issued repeated nationwide injunctions to implement a right-wing agenda. The problem there, of course, was forum shopping, court shopping, judge shopping. But if the case had actually been properly before him, and he was properly interpreting the law, which he was not, but it would necessarily lie that it should apply to everybody across the country. I mean, this is like saying in Brown versus Board of Education that the desegregation order should apply only to Linda Brown and the other plaintiffs in the case, as opposed to applying everybody in the country. That just doesn't make any sense. So we're going to oppose this very strongly. The bill is a betrayal of what, in fact, is objective, neutral, procedural mechanisms in the law that are well understood. And if it's unconstitutional for people in New York or Texas or Louisiana or California, it's unconstitutional for everybody in the country if it's a federal policy. Happy to yield back.
Gentleman yields back. The gentleman from California is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment in the nature of a
Without objection, the
substitute.
amendment will be considered as read. The gentleman is recognized to explain his amendment. And consider base text for the purposes.
Thank you, Mr. Chairman. The amendment modifies the title of the bill and makes it more easily understood. It is intended in no way to alter the important purpose of the bill, and I urge support. And I might caveat that we do have a number of amendments on our side that have been carefully worked out, that came in by members on our side who were equally concerned at making sure that this bill strikes a balance, not based on how many back and forths there are between who got more, but based on a growing trend of using these. And we believe that when the ranking member and other members on the other side see the amendments, they'll agree that the bill is intended to be balanced and is intended to preserve many of the things that the ranking member is concerned about. So with that, Mr. Chairman, I urge support for the amendment in the nature of a substitute and yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Kansas is recognized.
Thank you, Mr. Chairman, and I have an amendment at the desk.
Amendment to the amendment in the nature of a substitute.
Correct.
All right. I reserve a point of order, Mr. Chairman.
Point of order reserved by the ranking member. The clerk will report.
Amendment to the amendment in the nature of a substitute.
Without objection, the amendment to the amendment in the nature of a substitute will be considered as read. The gentleman from Kansas is recognized to explain his amendment.
Thank you, Mr. Chairman, and I want to thank the sponsor of the bill. I had raised in a much more limited fashion, but certainly some of the concerns that the ranking member has expressed in a much more, much broader fashion. The amendment is intended to provide a safety valve. Pardon me, could I have a drink of something here? Excuse me, Mr. Chairman. Is intended to provide a safety valve that provides that balance and makes sure that there is still an appropriate tool available in appropriate cases. With the chart that was discussed earlier, I was counsel to my client, the state of Kansas, on several, though certainly not all of those cases, certainly some of the 12 and some of the 14 during the Obama and Biden years. I might have been during some of the Trump years. I actually don't recall. I haven't gone back and looked at all of them. But representing a state is a different animal from representing a private party. In fact, the Supreme Court has recognized that for some purposes, for example, standing in some of these challenges, not that this is a standing issue, states have special solicitude in defending their role in our federal system. And certainly when the federal government, takes action, states may have an interest. So this amendment is intended to ensure that that balance remains available. It would provide essentially a carve-out provision that could apply in a limited number of circumstances where the base rule of the underlying bill, which is no nationwide injunctions, except only as to the parties, would apply. And the exception would be available when states are the parties, the plaintiffs, two or more states, in at least two circuits, depending on how many states, so that you don't have a parochial localized interest, tends to demonstrate a national interest. In that case, if a nationwide injunction is to be sought, the matter would be heard by a three-judge panel at the district court level under the ordinary statute that does those things, except we would provide that the appointment of the three judges for the panel would be randomized so that you don't have a circumstance where a chief judge, for example, might be tempted or able to handpick judges of a certain philosophy or predisposition. And then it would provide that in the event that a nationwide injunction is either entered or not entered if it's sought, a party would have the ability to appeal, if they so chose, directly to the Supreme Court. So this is designed to do several things. First of all, to minimize the benefit to plaintiffs of forum shopping, because you aren't certain who your judges are going to be, and to make sure that no single judge is in a position of entering a nationwide injunction that goes beyond the parties on these matters of sort of public policy concern. Second, to make clear that states have a particularized role in some of this federalist litigation as to the federal government. And third, to minimize the ability of litigants to gum up or delay process, which sometimes may be a portion of the strategy here. Just as justice delayed is justice denied, sometimes federal policy delayed can be justice denied. So that's the intent and what the amendment does. Mr. Chairman, I am grateful to Mr. Issa and to others who have worked with us on this at some length. Obviously, as a former state attorney general, I'm particularly sensitive in this area, and I think this cuts both ways. It would allow folks of both parties to use it.
Would gentleman yield?
Certainly.
I just want to make sure, I appreciate your work on this, working with the sponsor. I just want to make sure I understand it. Multiple districts, there could be an appeal to a sort of an expedited review to a three-judge panel with then the ability to appeal to the Supreme Court. Is that how we're, in the limited circumstance you described where it's involving multiple districts and it's action brought by states?
Yes, sir. State plaintiff, multiple state plaintiffs, plaintiffs from multiple circuits, goes to a three-judge panel and has an expedited review potential.
Multiple states, multiple circuits, three-judge panel, expedited review, with then a further review possible to the Supreme Court.
Correct.
All right. I think that I appreciate it.
Would the gentleman further yield?
Certainly.
And my understanding in our staffs working together on this so diligently and your personal engagement, you had examples of where it has been a practice to have three-judge panels when we really do want to make sure that it has the full weight and consideration, and that's what allows for a reasonable appeal directly to the Supreme Court.
Yes, that's correct. The existing statute with respect to three-judge panels applies in various circumstances. The one that most commonly has arisen in my own experience is with respect to redistricting, but there are others that are provided for by the statute, and then having the direct appeal likewise.
And this, further yielding, this by definition limits the ability of one judge, a rogue judge, well, in fact, not changing the fact that if it's a good decision, three judges will reach the same decision.
Absolutely, and that is the intention, to minimize to use the term of the statute, the title of the statute, the potential for a rogue judge, as the bill terms it, while still allowing access when it is truly necessary and appropriate.
Gentleman's time has expired. Appreciate his amendment. The chair now recognizes the ranking member.
Thank you very much, Mr. Chairman, and I thank the gentleman for offering this amendment, which on my standards, it takes an F bill and turns it into a D- bill. So I will support it, but I don't think it gives the bill a passing grade, because when I look at the litigation that's been brought in the first furious 6 weeks of the Trump administration, there have been overwhelming victories against the Trump administration, as the chart helpfully instructs, but only a handful of them come from states. So, for example, there's a win with New Hampshire on the birthright citizenship issue, which of course it was blatantly constitutional to attempt to just nullify birthright citizenship, the very first sentence of the 14th Amendment. And New York versus Donald Trump, which had to do with illegal disclosure of personal and financial records to the DOGE group, the Department of Government Efficiency. So there were wins there, but most of the wins came by individuals. So take, for example, the removal of independent agency leaders in American Federation of Teachers versus Besant, or Dellinger versus Besant. I mean, the vast majority of those being harmed by the Trump-Musk offensive against our Constitution here are individuals. They're people who are beneficiaries of Social Security or Medicare or Medicaid. They are individual workers at the NIH or at the NOAA, the National Weather Service, who are being sacked unilaterally and arbitrarily by the administration and so on. Those people should have equal rights to get into court, and they have interests that are replicated all across the country. So obviously that provision would then channel everything into state litigation in order to have nationwide clarification of what people's rights are. But I just don't see the logic of carving out that exception. I'm willing to vote for it because, again, it makes a really unnecessary and retrograde bill slightly better. But it doesn't solve the basic problem that we're nullifying TROs and preliminary injunctions on a nationwide basis when they apply nationally to people who are being harmed by offensive governmental action. I yield back.
Would the gentleman yield?
Oh, yes, I would.
You know, I might say that if you look at the amendment, the second paragraph, where it says page 1, line 17, that in fact does encourage the formation of a class action so that it would include, if you will, the entire class. But I think the most important thing, and I'll ask it as not as,
if you did interrupt, if I could interrupt for 1 second, maybe we got the wrong amendment because. Oh, this is your amendment, rather?
Yeah.
Oh, gotcha. Okay.
But we're sort of doing two at once as we speak. But Mr. Ranking Member, the rhetorical question I'm asking, and it's not completely rhetorical, is if we look at the allegations made against the current president in these various cases, if the world were as just as it could be and the court was as good as it would be, would it not form a three-judge panel in a matter of days, just as quickly as a single judge, convene, make a decision, and the Supreme Court act in an expedited fashion, so in a very short period of time, uncertainty would be consistently resolved? Wouldn't that be the best case as compared to today, where you may or may not get injunctive relief, and it can be uncertain? You know, what the gentleman, Mr. Schmidt, has done here is he's created, for the most common case, which is states objecting to these actions, he's created, I think, a very clever expedited possibility. It may be a bit of a burden on the Supreme Court, but ultimately these cases get to the Supreme Court, and he has come up with, I think, a good protective way to get to the court quicker. And when the shoe's on the other foot, I know that you're going to love this. The shoe is not really bad today. As you said, D-. You know, I'm a Kent State graduate. That's a passing grade. I'd like a C, but you know, I'm thank you for getting off the F.
Well, but again, I'm going to support his amendment because I do think it makes it marginally better. But to me, it doesn't redeem the whole enterprise because the system is working, and it's working in a necessary way here. I don't understand our colleagues' determination to try to remove every obstacle to what Donald Trump and Elon Musk want to do, even constitutional obstacles. even legal obstacles. I thought as the Judiciary Committee, we would really be determined to stick with the law.
The time of gentleman expired. The question occurs on the amendment offered by the gentleman from, the amendment to the amendment in the nature of a substitute. All those in favor say aye. Aye. Those opposed, no. In opinion of the chairs, the ayes have it. The amendment is adopted to the, is added to the amendment, in the amendment in the nature of a substitute. Who seeks recognition? Gentleman from Georgia is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Reserve a point of order.
Point of order reserved by the gentleman from California. Clerk will report the amendment.
Amendment to the
Without
amendment.
objection, the amendment will be considered as read.
I'd object to the waiving of the reading.
Okay, the clerk will read the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1526 offered by Mr. Johnson. Page 1, insert after line 3 the following and redesignate succeeding sections accordingly. Section 2, findings. Congress finds the following. Since taking office, the Trump administration has sought to tear apart our democratic institutions through unlawful and unconstitutional executive actions. Because federal courts keep ruling against the administration, Republicans in Congress are seeking to change the laws to help the Trump agenda. 2, the court in Casa v. Trump, when imposing injunctive relief, found that, quote, the executive order flouts the plain language of the 14th Amendment to the United States Constitution, conflicts with binding Supreme Court precedent, and runs counter to our nation's 250-year history of citizenship by birth. The president does not have the authority to strip them of their constitutional right to citizenship by birth. 3, the court in National Council of Nonprofits versus OMB, when imposing injunctive relief, found that the, quote, defendant's actions in this case potentially run roughshod over a bulwark of the Constitution by interfering with Congress's appropriation of federal funds, and it attempted to wrest the power of the purse away from the only branch of government entitled to wield it, end quote. 4, the court in Washington v. Trump, when imposing injunctive relief, found that, quote, the United States Constitution exclusively grants the power of the purse to Congress, not the president, and the president does not have unilateral authority to refuse to spend the funds Congress appropriates. The executive order thus amounts to an end run around the separation of powers. Not only has the administration claimed for itself Congress's exclusive spending power, it has also attempted to coup Congress's power to legislate, end quote. 5, and the court in New York v. Trump, when imposing injunctive relief, found that, quote, the executive statement that the executive branch has a duty to align federal spending and action with the will of the American people as expressed through presidential priorities is a constitutionally flawed statement. The executive branch has a duty to align federal spending and action with the will of the people as expressed through congressional appropriations, not through presidential priorities, end quote.
Gentleman's recognized.
Thank you, Mr. Chairman. I thank the clerk for her reading of that. The judicial branch ensures that people, corporations, and even other branches of government follow the law. And if a government entity does something illegal, the only way for the court to prevent thousands of people from being harmed is to order a nationwide injunction that stops the government from doing that illegal thing. It is essential to our democracy that the courts can serve as a check on an executive branch or even a legislative branch that is trampling people's rights. While proponents of the underlying bill say that everyone should bring their own cases, that just doesn't make sense. There is no way that each of the thousands of people harmed could pay for their own lawyer, get into a courtroom, and try their own case. Aside from the difficulty and cost to everyone, our courts could never handle that volume of cases. Their dockets are already bursting at the seams, and justice would be so delayed that it would be denied by default. Plus, that might lead to unfairness and variation if judges one state or one county over rule differently on the same set of facts. It would be inefficient, cost prohibitive, unfair, and unjust. Republicans only want this bill because federal courts keep ruling against Trump's unlawful and unconstitutional executive actions. Therefore, they are trying to hamstring the courts from stopping him. We need our courts to continue to serve as a bulwark of democracy against the Trump administration's flood of illegal actions. That's why I object to this bill. However, if the bill is to move forward, I believe it should include my proposed findings, relaying the court's vivid language about why the injunctions they are imposing were so necessary and so vital to American democracy. This includes the court's opinion in National Council of Nonprofits versus OMB that the administration's actions, quote, potentially run roughshod over the bulwark of the Constitution, end quote, and that the administration, quote, attempted to wrest the power of the purse away from the only branch of government entitled to wield it, end quote, namely us in the legislature. My findings amendment also includes the court's opinion in Washington v. Trump, stating that the executive order in the case, quote, amounts to an end run around the separation of powers, end quote. This is important information that needs to be a part of the record when we are deciding whether to completely upend the delicate system of checks and balances that has sustained our democracy for nearly 250 years. I hope that you will support my amendment, although I will be voting against the underlying bill. And with that, I yield back.
Will the gentleman yield for 1 second?
I'll yield to the ranking member.
Thank you, Mr. Johnson, and thanks for your thoughtful amendment. It occurs to me that our colleagues would invite this checkerboard approach where you'd have to bring a lawsuit in 50 different states, and then 43 might say, for example, the birthright citizenship executive order is clearly unconstitutional. As one Reagan judge put it, he said it was the easiest case he'd ever had to decide, and you don't need to be a lawyer, you just need to know how to read in order to reject this. But maybe you could get a handful of judges to say, no, it's constitutional. Then you've got this fragmented checkerboard approach. In any event, why not just let it work its way up? And so that we could get a decision by an appeals court and the Supreme Court, rather than going from 46 injunctions, which is what we've got now according to this useful chart, to 46 times 50 injunctions, right? 2,300 injunctions in the country. I mean, that's a total waste of judicial resources and an offense to judicial economy. We yield back.
Gentleman yields back. Gentleman from California is recognized.
Thank you, Mr. Chairman. I'm not reluctant in opposing this amendment. I'm a little surprised at the nature of it. It was kindly I also join in thanking the clerk for reading the full bill. The amendment, as I see it, is best seen as footnotes of opinion as to the bill, and not something that would normally be found in a law. So for that reason, the reason that it doesn't really read, it reads like a piece of history, not like an amendment, I'm going to oppose it. But I do want to speak to the underlying bill briefly. This amendment implies somehow that it's all about President Trump, and it's not. This bill is about fashioning a process that works well in both parties. And I want to thank the gentleman from Kansas for making sure in the amendment that now has been agreed to this amendment, that it does it better. I might note that when Mr. Schmidt was Attorney General, the fact is 16 states came together, 16 attorney generals. That represented all the people of 16 states. There was nobody left with the burden because through their elected process, they had created someone to represent them. They had pre-agreed to someone to represent them. What we're trying to deal with in the underlying bill is that one person who doesn't like something that's been done can go to one judge and affect an entire workforce nationwide. Those people may not choose to object. They may be quite pleased with it. They haven't been given a chance to be a party, and they have not voted for representation. I suppose, in collective bargaining, you do vote or you do ask for representation, but they don't. This is one individual going to one judge. So I would say that when this becomes law, it is very possible that we will see more states' attorney general on behalf of 2 or more states choosing to go through the process to quickly get a decision from a 3-judge panel, quickly go to an expedited event at the Supreme Court, and we will see swift justice, not justice I like, not justice the other party likes, but justice is defined in our Constitution. So I'm going to oppose this and ask that we simply move on to the underlying bill, which I think now is something that even the ranking member has given it a low but passing grade. And with that, I yield back.
Gentleman yields back. The question occurs.
Mr. Chairman.
The gentleman from New York is recognized.
I yield to the gentleman from, I move to strike the last word.
Gentleman is recognized.
I yield to Mr. Johnson.
I thank the gentleman for yielding. The gentleman from California argues that this legislation is not put forward in response to supporting Donald Trump's recklessness and unlawfulness, but I submit that the timing of the filing of this legislation is particularly coincidental. It was just filed last week after these various courts have issued rulings against the Trump administration, and I don't think any such legislation has been filed in the past that would take or rip away from federal district court judges the ability to issue injunctive relief that applies across the board, more than just to the individuals before the court. So this is a revolutionary, extreme proposal that has been put forward. It has not had benefit of a hearing, where we can hear from all of the various sides, if there are any. I think there's not too many folks who want to rip away the power of federal district court judges to issue injunctive relief on a broad scale. But if there are, we certainly would need to hear from them, hear their arguments, and find out what is it that compels us to have to change the law, a law that has a part of the law that judges, in other words, judges have been issuing nationwide injunctions for at least a century. And for us to change on a dime, that practice, that part of our jurisprudence just doesn't make good sense to me at this particular time, particularly since we've not had a hearing on the merits of this legislation. So for those reasons, I ask that the findings that I'm asking to be included in the legislation be included, that this amendment pass, because it's important that we have a record of why this legislation is being passed at this particular time. And with that, I'll yield back to the gentleman from New York.
No, yield back.
Gentleman yields back. The question is on the amendment to the amendment in nature as substitute. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. The question now occurs on the amendment.
Mr. Chairman.
Oh, I'm sorry, there is someone else.
Yes, there is.
For what purpose does the gentlelady seek recognition?
Mr. Chairman, I have an amendment at the desk.
I thought you might.
I
The
told
clerk-
you in advance.
I know you did,
See how
very
courteous
kindly.
I am?
Okay, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 15.
The amendment, I would unanimous consent, the amendment. The gentleman reserves a point of order. Ask unanimous consent, the amendment be suspend the reading, and the gentlelady is recognized to explain her amendment.
Thank you, Mr. Chairman, and also the sponsor. I'm surprised that my colleagues on the other side of the aisle are now trying to prevent federal district court judges from issuing nationwide injunctions. They had no issue with such injunctions 2 years ago when Judge Kaczmarek issued a nationwide injunction against the FDA's approval of abortion medication, an injunction riddled with errors and which the Supreme Court later reversed for lack of standing. Last Congress, as the chairman knows, I introduced a bicameral bill, the Fair Courts Act, which would have helped reform our justice system so cases in which plaintiffs seeking a nationwide injunction would have to have their case heard by a 3-judge panel instead of a lone judge. So 3 judges as fact finders, similar to the amendment that we saw for the AGs. My bill would have addressed strategic litigation by plaintiffs filing in specific districts, knowing that their case would go in front of a friendly judge who would give them the outcome they wanted, along with facts that may not be true. Unfortunately, Republicans then did not think a single district court blocking an administration action nationwide was a problem. Now that district court judges appointed by presidents of both parties, including President Trump, are blocking the new administration's actions, it's suddenly a problem for my colleagues on the other side. However, I still think the problem of judge shopping is in this bill and could be abused. So my amendment would ensure that when a plaintiff files a suit in a district court, there's no more than a 25% chance that it would go before any particular judge. I think we can agree that litigants should not be gaming the system by picking their judges in advance. And my hope is that my colleagues on the other side of the aisle will support my amendment. And I'm happy to answer questions about the details. In many judicial districts, this wouldn't be a problem because they do have random selection. But in this particular small Texas federal district, you only get one judge. And lots of people have been going there to seek his wisdom or lack thereof.
Will the gentlelady yield for question?
Yes.
So if you would explain a bit further when you said there would be no more than a 25% chance of any particular judge drawing a particular case, can you explain how that happens, especially if there's just one judge in that district?
Right. So what would happen is, and this is on, it starts on line 10 of page 2, where you're talking about low population districts. And so a low population district is a district that doesn't have enough judges to ensure the 25% probability. So you would use then, starting on line 18, judges from adjacent districts so that you would have enough judges to be able to have this randomness. And you know, this may not just apply in this one Texas district. It could apply in areas where there would be a particularly liberal judge. So this is completely agnostic as to who appointed you. It's just about not allowing that kind of judge shopping.
Can you yield for one other question?
Absolutely.
The judge in Judge Kaczmarek's case, the lone judge in a low population district, would that judge also be part of the lottery so they could be drawn?
Correct. So that we would not be making sure, we would not be saying that that judge could never hear these cases. We're just saying that basically any litigant couldn't be assured of having that judge so that they may consider filing in a different venue.
Okay, now would you connect what you want to do, which seems perfectly logical and compelling, to the general subject we're talking about, which is nationwide injunctions?
So my bill that I introduced last Congress actually is very similar to how we do it in North Carolina, that if you're going to have a statewide injunction on something that has to do with a fundamental constitutional issue, not necessarily a statutory issue, but a constitutional issue, that there would be a 3-judge panel and that it would actually have to be politically diverse and geographically diverse in order to be able to have a constitutional issue have that full injunctive relief. But that bill was not given a hearing. Again, we had a Senate sponsor, Senator Wyden. Had we passed it, you would have been able to benefit from it this year. So see? You should have taken it up in the court subcommittee last Congress. I think we could have gotten bipartisan support. But here we are today, and I would appreciate the members supporting this amendment, and I yield
Would the
back.
gentlelady yield just for a moment?
I yield even though I'm over my time.
Well, I can't see that right now. I'm looking at you. I believe the gentleman's going to insist on his point of order as not germane. But if he does, because the parliamentarian has whispered to me that that happens to be the case, that it won't be, what I will tell you is I support the concept of it. If you look at the patent pilot bill, which ancient years ago, it specifically tried to do the same thing to prevent somebody grabbing a bill. And we have repeatedly reminded the people in both East and West Texas, where one judge keeps grabbing bills, that that was an intent we wanted to. So I'd be happy to work with the gentlelady on a separate bill. I will guarantee a hearing in the subcommittee, because I do believe that forms of randomization that ensure that you can't forum shop, particularly in smaller areas where it naturally happens. Absolutely, the gentlelady is right and is well within our committee's jurisdiction. So if I failed to serve you properly in the last Congress, I will tell you, notwithstanding a vote here today, that I will serve you better this Congress.
Well, I appreciate that. I do believe that this amendment is germane, because I was thinking about just simply substituting my bill from the last Congress in this and was told other parts were not germane. So I do believe that this amendment is germane, and I would appreciate a vote on that. However, should I not prevail, I surely would love to introduce this as a bill.
I thank the gentlelady. Now does the gentleman continue to assist on his point of order?
The chairman has uncannily read my mind. I was just wondering if I could get a palm reading, too.
And if the parliamentarian will rule? Does the gentleman,
Yes.
I already did that. The gentleman,
Am I recognized, Mr. Chairman?
the gentleman is recognized to explain germaneness.
Thank you, Mr. Chairman. The gentlelady's amendment would introduce material beyond the scope and purpose of the bill before us, and therefore it violates House Rule 16 of Clause 7. I yield back.
The gentleman yields back. Does the sponsor of the amendment wish to be heard on the point of order?
That's fine. I disagree, but I'm not going to appeal because I'm going to get my whole own hearing in the court subcommittee.
That is true. Okay. I'm now prepared to rule. The gentlewoman's amendment does not satisfy the subject matter and fundamental purpose test. Therefore, it is not germane and is ruled out of order, but the promise continues. Who else seeks recognition? The question is on the amendment to the amendment. I'm sorry. Next page. There we go. The question is on adoption of an amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor, please say aye. Aye. Any opposed? No. In the opinion of the chair, the ayes have it. The ayes have it. Hold on. Sorry about this, I'm having a bad time with the button. The question is on favorably reporting the bill as amended. All those in favor of that bill, please say aye. Aye. Any opposed? No. In the opinion of the chair, the ayes have it. The ayes.
Seeking recorded vote.
The gentleman requests a recorded vote. The clerk will call the roll.
Mr. Jordan? Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Gill votes aye. Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Jordan? Mr. Jordan votes yes. Mr. Van Drew votes no. Mr. Van Drew votes yes.
The gentleman from Washington.
Mr. Baumgartner votes yes.
I was wondering who else sought recognition. There are so many.
Mr. Gooden votes yes.
The gentleman from Missouri.
Mr. Onder votes aye. Ms. Hageman, you are not recorded. Ms. Hageman votes aye. Mr. Fry, you're not recorded. Mr. Fry votes aye.
The clerk will report.
Mr. Chairman, there are 14 ayes and 9 noes.
The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill is adopted as a single amendment in the nature of a substitute incorporating all adopted amendments. The staff will be authorized to make technical and conforming changes. This concludes the committee's business. The markup is adjourned.